May it please, my lordship.
Yes.
Lordship, I beg to mention item number 10. In this matter, we are awaiting some documents that were submitted before the DC Newland. And since it was a new district, some miscommunication files are there, and that's why we are awaiting for some crucial documents that were submitted from long time back before the ADC. So we are awaiting for some time. So my lord, will you kindly grant us? Even government has not filed their affidavit.
Then, learned government advocate, Ms.
Last
Inatuli has prayed for how much time?
3 weeks, Your Lordship.
3 weeks time to file the counter affidavit. You are for?
I'm for the petitioner.
Okay. And
I am on the.
and Learned Counsel Z. Zimomi, Ms. Z. Zimomi, appearing for respondent number,
Private respondent.
private respondent, and has also prayed for 3 weeks time to file the counter affidavit. Learned Counsel for the petitioner, Mr. Fusiko, has no objections to the same. Prayer is allowed, least after 3 weeks.
Lordship, there's an interim. Kindly let it
The-
in your lordship.
Interim is there.
Yes, my lady.
Okay.
There's an interim.
The interim order shall be extended till the next date.
Obliged, lordship.
Obliged, my lord.
Yes.
Lordship, I also like to mention item 15.
15.
Here I'm for the respondents.
Yes.
Respondent number 6 and 7. I'm for the insurance.
Yes.
Lordship, I need some time. So kindly. grant
Item
3 weeks.
15.
15.
And petitioner,
Petitioner, I'm told you have some engagement, so you coming.
learned counsel for the petition is not present when the matter is called. However, learned counsel, Mr. Fusiko, for the respondent number 6 and 7, has prayed for how much time?
3 weeks, Lord.
3 weeks time to file the counter affidavit.
Lord.
Yes, prayer is allowed, list the matter after 3 weeks. Government has filed.
Your Lordship, I'm also seeking time.
Okay. Learned government advocate, Ms. Nauli has also prayed, made a similar prayer. Yes. This after 3 weeks.
Last matter.
May I please, Your Lordship?
Yes.
I beg to mention item 18, Your Lordship. Here,
Item 18.
instruction is awaited, so kindly let this matter be listed after 3 weeks, Your Lordship.
18.
Yes, Your Lordship.
Learned government advocate, Ms. Nauli has prayed for 3 weeks' time to file the, to receive instructions in this matter. Learned counsel for the petitioner is not present. List the matter after 3 weeks.
Much obliged.
Yes.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 14.
Hmm.
And this matter, Your Lordship, I am praying for respondent number 1, 2, and 3.
Hmm.
If some time can be granted to file my counter affidavit, Your Lordship.
Learned senior government advocate, Mr. N. Angami, appearing for respondent 1, 2, and 3, has prayed for
At 3 weeks.
3
time.
weeks' time to file the counter affidavit in the present case. Learned counsel for the petitioner, Fosiko, is present and has no objections. List the matter after 3 weeks.
Lordship, Lordship,
Yes.
by order 24/6/25, I was directed to take steps upon the respondent 4 and 5 by way of Dusty.
Hmm.
I have filed an affidavit to that effect, Lordship.
You have filed.
Yes,
Okay.
so the service upon respondent 4 and 5 may be deemed complete.
Okay. Learned counsel for the petitioner also submits that the service upon respondent number 4 and 5
4 and 5.
4 and 5 has been served by Dusty Mode as instructed, as directed by this court, and affidavit to that effect has been filed.
Oh.
Stop. Therefore, the service on respondent number 4 and 5 is deemed served.
Obliged.
Like my
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 16, Lordship.
Hmm.
Here, the state respondent is here to file affidavit in opposition, Lordship. If Lordship may please to grant another 3 weeks time, Lordship.
Learned government advocate, Mr. V. Jimomi, prays for 3 weeks' time to receive instructions and file counter affidavit in the present case.
I have received the instruction. Lord.
Okay.
Your Lordship,
To
my
file-
learned friend was supposed to finish the drafting
Oh.
during the vacation.
Lordship,
This
this is 2025 matter, Lordship.
No, it doesn't matter, Your Lordship. My client,
But
after the conviction, on the basis of the conviction itself, he was terminated from service.
Hmm.
On appeal before the Dissolvent Court, he was honorably acquitted by the Dissolvent Court.
Hmm.
So he should have been directly reinstated, but it did not happen. So he's been out of job for many years, and my client is really struggling, my Your Lordship.
Disciplinary proceedings also done.
In fact, no disciplinary proceedings, Your Lordship.
Oh,
Only because he was convicted, he was terminated from service. Your Lordship,
mm.
there's urgency in the
3
matter, my
weeks.
lord, I kindly consider.
my Lord, 3 weeks time,
Okay.
Lordship.
3 weeks
Lord.
as a last chance,
Lord.
as a final opportunity for the state respondents, please after 3 weeks.
Obliged.
Lordship, Lord.
May I please, Your Honor?
Yes.
I beg to mention item 4 on behalf of additional AGM himself.
Hmm.
I pray for 3 weeks to file an affidavit.
Learned government advocate, M. Longcomer has prayed for 3 weeks' time to file affidavit on behalf of the learned additional AG, Mr. M. Tim. So, prayer is allowed, listen to 3 weeks.
Your Honor, I have a similar prayer for item 8 on behalf of additional AGM himself.
There also counter.
Yes, Your Honor.
Item 8 also, similar prayer on behalf of Mr. M. Tim Song, additional AG, to file the counter affidavit, this after 3 weeks.
And Your Honor, item 9 on behalf of S. Chang, government advocate.
Item 9.
Need some time to file affidavit. We have sought for some
But
time.
you have sought permission from the petitioners, I hope,
Your
in all
Lordship,
these cases.
I'm appearing for
Ah.
item number 9. So
Okay.
Lordship, if this can be the last chance granted to file the affidavit in opposition. This is for commissioned appointment, Your Lordship. 6 years has been passed since my application has not been granted.
Hmm.
And even after filing RDI, we came to know that my name doesn't appear in any of the waiting lists under this district, any of the district.
Hmm.
So if they can instructed to bring the instruction
Hmm.
by the next.
Okay. You're appearing or who's appearing in this
S. Chang
item,
is
item
appearing,
9?
Your Honor.
Okay. Learned
Make an endeavor.
Yes, learned counsel, learned government advocate, Mr. M. Nokoma has prayed for 3 weeks' time to file the counter affidavit on behalf of government advocate S.
Yes.
Chang. Learned counsel for the petitioner has prayed that this may be the last opportunity as the petitioner has been waiting for the past
6 years.
6 years to be appointed on compassionate ground. Stop. An endeavor shall be made by the government advocate concerned to file the affidavit by the next date, least after 3 weeks.
Obliged.
Obliged, your lordship. May I please, your lordship?
Yes.
Lordship, I beg to mention item number 5
Item 5.
on
Yeah.
behalf of LD Sangam additional AG.
Hmm.
Lordship, we kindly grant 3 weeks time to file affidavit.
Prayers made on behalf of Mr. L.T. Sanctum Additional AG
Item number 5.
for 3 weeks' time to file
Item number
affidavit
5.
in opposition on behalf
May I
of the
please,
state
ma'am?
respondents. Yes,
My lord, we would like to withdraw the petition, my lord.
withdraw.
My lord.
Oh, okay.
Because there's already a civil suit filed in the civil.
Ah.
should recall the other time I was mentioning there's a civil suit on the same issue.
Okay.
With liberty
Lord,
to agitate the same before the civil judge.
No, if you have already filed, if there's already a civil suit, then it's understood that you have to go and contest.
My lord,
Yes. Learned counsel for the petitioner,
I Jamil.
praise for withdrawal of the writ petition. Stop. Accordingly, the matter is disposed of on withdrawal. Yes.
Obliged.
Lordship, I also like to beg to mention item number 25 and 26 for the hearings. On behalf of additional AG in teams,
25 and
Lordship.
26,
kindly desist matter after 2 weeks.
on behalf of,
LD Sangam.
oh. This is a fixed matter actually.
Your lordship, but he has taken my consent. Apparently,
Oh.
he has some urgent matters outside the court, so.
Learned government advocate, Pichano Kitan has prayed for 3 weeks' time.
But your lordship, make it 2 weeks.
2 weeks, Lordship.
2 weeks' time, on behalf of Mr. L.T. Sanctum, who has some personal difficulties today. Accordingly, list the matter after 2 weeks.
Lordship.
Yes.
Lordship, item number 17. Here I need to receive instructions so far. 17, Lordship.
17.
Here I need to receive instructions, so 3 weeks time I kindly grant to Lordship.
Okay. Learned counsel for the petitioner is present. Learned counsel for learned government advocate, Pichano Kitan, prays for 3 weeks' time to file the counter affidavit. Prayers allowed, list of the 3 weeks.
I pledge.
Yes.
May I please, your Lordship? Your Lordship, I beg to mention item number 3.
Item
3.
3. Yes.
Your Lordship, we are yet to file our affidavit in reply, so please grant us 3 weeks.
Learned counsel for the petitioner, MS such and such, prays for 3 weeks' time to file an affidavit in reply to the counter affidavit of the government respondents. Stop. Prayers allowed. The learned government advocate M. Longcombe is present. List the matter after 3 weeks.
Lordship.
Yes.
Perhaps my lady.
Mm.
In item 15, my lady, I've wrongly cited my respondents. I'm for respondent 8, in item 15.
In item 15,
Yes,
okay.
I have.
Instead of 6 and 7, you say respondent 8, okay,
8.
for Siko.
Please.
Please, your lordship.
Yes,
I'd like to mention item number 19.
okay.
I pray that 2 weeks time may be granted to file an objection to the petition filed.
You are for
I'm for respondent number 2.
respondent 2. Okay. Learned counsel, MS such and such, appearing for respondent number 2, has prayed for 2 weeks.
2 weeks.
2 weeks time to file an affidavit in opposition. Affidavit in opposition. Stop. Learned counsel for the petitioner is present. And there's no objections. List after 2 or 3 weeks. 2 weeks. 2
Lordship,
weeks.
there's an interim.
The interim order passed earlier shall continue till the next date.
Obliged, lordship.
Please, your lordship.
Yes.
Lordship, I beg to mention admission item number 1.
Admission 1.
Yes, Lordship. Lordship, here we are yet to file affidavit in reply.
Hmm.
So if you may please kindly allow us 2 weeks' time to file the affidavit in reply.
Wait. Admission
Item
start
2.
only from 2, yes. Item 2. I think you mean item 2, WP 91.
Item 2.
Yes. You want to file?
Affidavit in
Reply.
Yes,
Okay. Learned counsel for the petitioners, such research and such praise for how much time?
2 weeks time.
2 weeks time to file affidavit in reply to the counter affidavit filed by the state respondents. So, learned government advocate now is present. Prayers allowed, list the matter after 2 weeks. Yes.
My presence may also be recorded. It is not shown in the.
It is
court
not
list.
shown,
Referring to
ah.
The respondent AG.
Okay, R
9. Respondent number 9, Your Lordship.
R9. Learned counsel, Mr. Joshua Sheki is present for the respondent number 9. The name of Mr. Joshua for respondent number 9 may be reflected. You said the registry is directed to reflect the name of Mr. Joshua as respondent for the respondent number 9 in the cause list.
My Lord.
Yes.
Much obliged.
Yes.
My pleasure, Lordship. Lordship, I'd like to mention item number 12 on behalf of Kian Gami. Kindly grant 3 weeks.
Item
time to-
12.
Lordship.
Yes.
Lordship, if I may,
Yeah.
for the petitioner here,
Yes.
there's an urgency in this matter.
Hmm.
So last chance may be given, Lordship.
What is the issue?
It's a dispute in computing his length of service. So had my petition not been considered,
Hmm.
I will be retiring by February, and by now I'll be receiving my release order.
Release order.
So if my petition is not reconsidered, it will affect my pensionary processes.
Joshua, you're also here.
Yes, Your Lordship, I'm for the respondent number 5, but here also my name is not. reflected.
R5.
Yes, Your Lordship. Not only that, our presence is not required in this case, but the Honorable Court has refused to
Delete.
drop our name, just delete our name from the case. Because we have no role to play.
Learned government advocate Pichano Kitan has prayed for.
Kian Gami.
No. How much time?
3 weeks time, Lordship.
3 weeks time to file the counter affidavit on behalf of Mr. K. Angami, learned senior government advocate. Stop. Learned counsel for the petitioner, MS such and such, prays that there is an urgency in the matter and the matter needs to be expedited. Stop. Accordingly, the government advocate is directed to make an endeavor to file the counter affidavit by the next date. Learned counsel, Joshua Sheki appears for the respondent number 5.
My Lord.
There is an interim, Lordship.
The interim order passed earlier shall continue till the next date.
And my Lord,
Yes.
in the post list, my name may be reflected. By
Oh, yeah. The registry is directed to reflect the name of Mr. Joshua Sheki as the counsel appearing for respondent number 5.
My Lord.
Mm.
Lordship.
Lordship.
Petition, Ladyship,
Yes.
I beg to mention item number 14. We have an instruction to
Right.
enter on behalf of respondent number 4.
Item
Item number 14.
14.
Yes, Your Lordship.
14 is already mentioned, I think.
We have filed our wakalat nama.
Mm. Item 14 already, yes. In that you say you are Faklat number for petitioner or for whom?
Respondent number 4.
For respondent number 4 and 5. Okay. What order did we pass in item 14? Just see. That dusty mode, I think, no service. Oh, then we'll have to change that. You delete that part where I've said that the service on respondent number 4 and 5 is deemed served, na? That line, okay? Just delete that part, and instead of that, you say, learned counsel, your name.
Benison Bishoy.
Yes. Enters appearance for the respondent number 4 and 5 and submits that he has already filed. You have
Yes,
filed his Vaklatnama and prays for how much time?
2 weeks.
2 weeks.
3 weeks.
3 weeks to file his affidavit. 4 and 5 have appeared
Lord.
to file his affidavit in opposition. Praise allowed. How much time did we give? 3 weeks. In 14 earlier, 3 weeks. 3 weeks, okay, 3 weeks.
Published. For motion, item number 1. Okay.
Yes.
The petitioner sharing aggrieved by the selection process which is going on presently of excise constables.
Mm,
The physical test started on 14th and it is to finish today.
mm.
That is the position. Now I'll take your lordship to the urgent
Physical,
that report.
physical test started on
14th.
14th.
Yes, and today, 24th, is the last day of the physical test.
Mm,
I'll take your lordships to the report, your lordship. Annexure P, your lordship, this is the advertisement. Annexure B. Page 30. Page 30.
which, yes.
So I'll take your lordships from criteria and requirements, your lordship.
Mm,
Educational qualification, class 8 passed. Then age limit, it's okay. Minimum height, okay, but 4. This is the important,
1 minute, you're reading from page 30.
yes.
30.
Page 30, yes. Page 30, if your lordship may go down, criteria and requirements. Under that,
Criteria and requirements.
yes,
Wait.
criteria and requirements, the
Mhm.
third paragraph, and then 4, if you, serial number 4,
Mhm.
serial number 4,
Criteria and requirements. One is educational qualification, age
class
limit,
8, yes,
minimum height,
yes.
then recruitment
4,
process.
this is,
Yes,
recruitment process is A, physical test,
physical test, suitability
yes,
test.
and B, suitability test.
Mhm.
So as per the advertisement, there are to be 2 tests. Now this is perfectly in keeping with earlier advertisements, Lordship,
Mm.
which is in the next annexures, C1 and C2. These are the earlier advertisements.
C1. Recruitment process, physical test, suitability.
Physical test, B, suitability test.
And C1,
And
C2.
page
Physical
33 and
test.
34,
Suitable test. Okay, suitability test meaning viva.
Viva only, Viva only. See, this is for constables.
Hmm.
The emphasis is more on the physical aspect, Your Lordship.
Okay.
So
Mm.
now,
Then,
for the physical test, there is an office memorandum.
okay.
Since the service rules is silent about how to, for the physical, how to.
Mm. How to
assess
conduct.
the physical
Mm.
fitness,
Mm.
which is at annexure T, page 36.
Mm.
The typed copy is in the next page, that is page 37. This is a memorandum dated, actually it is 19 July 2016, the signature of the Commissioner of Excise is given, page 38. If your lordship may go to page 38. 19/7/2016.
19/7/2016.
Yes. Up here, the date is March, it is given, but no specific date is
No
given.
date is there.
Yes, but
But
the
signed
actual-
on 19/7.
yes, 19/7/2016.
Mm.
So I'll take your lordship to the page 39, which is the typed copy. Page 39 is a second copy, second page.
Mm.
Here, number 3,
Mm.
in the middle, if your lordship may go to the number 3 serial.
Mm. Mm.
Those candidates who meet the physical standards as specified will be put through physical efficiency test as indicated below.
Mm.
So these are the tests. 100 meters race,
Mm.
males, it is 16 seconds. For females, it is 18 seconds. B, 800 meters race, males 3 minutes, females 4 minutes. C, long jump, 3.5 meters for men in 3 attempts, 2.75 meters for women in 3 attempts. 3 chances will be given. D, high jump, that is 1.05 meters for men in 3 chances, 0.90 meters for women, 3 chances. Then E, short put, 7.26 kilos. That it should be drawn 4.5 meters for men only, not for women. So this is the, among others, this is the test they are to undergo because it is only physical and viable. Now, I am also aggrieved by, if your lordship, I'll go serial wise, also page 40. This is page 40, annexure E1. The typed copy is at page 41. This is setting up of the departmental recruitment board. It is not in accordance with the service rules. I'll take your lordship through the service rules also, but here 6 members have been appointed. Representative Commissioner of Excise is the chairman, representative of BNAR, representative of finance, representative of law and justice, representative of administration department, additional commissioner of excise, member secretary. So they have, this is the approval by the government, and then the notification, which is at the next page, page 42, annexure E2. So I'm also aggrieved by it. Now, lordship, I'll take your lordship to the extant service rules, which is it starts from page 43. And Nagaland Excise Service Revised Rules 1999, which is at page 43. Now, I'll take your lordship to page, Rule 5 and Rule 7 specifically. Rule 5 and Rule 7. Rule 5, page 46 here, Lordship, page 5. Recruitment to the service after the commencement of these rules shall be by any of or all of the following methods. By direct recruitment through competitive examination selection. Number B, by promotion of members of the service having put in minimum years of service as prescribed in Schedule 4. 2, notwithstanding anything contained in sub-rule 1, if in the opinion of the government, this is important, the government has to make the changes where if any changes is to be made. That is what I want to. The exigencies of the service so require, the government may, in consultation with the commission means the NPSC. Your Lordship. Yes. Adopt such methods of recruitment to the service other than those specified in the said sub-rule as it may by order issue in this behalf be prescribed, provided that the quota allotted to each source of recruitment under clause A and B of sub-rule 1 and the minimum educational qualification and all conditions for recruitment shall be as mentioned in Schedule 2 and 3. So this is with regard to the recruitment. Government, if any changes are to be made, it is to be made by the government in consultation with the commission. Now, Rule 7. Rule 7, page 47. This is with regard to constitution of selection interview board and departmental promotion committee to non-gazetted posts. 1. Selection for direct recruitment and promotion to the posts of Assistant Inspector of Excise, Head Constable and Excise Constables shall be made by a board committee consisting of the following members. Number 1, Head of the Department, Chairman. 2, Representative from Administrative Department. Number 3, Representative from PNAR Department. And number 4, an officer nominated by the Head of Department from the Directorate, Member Secretary. So 4 of them are clearly specified here. Now, in violation of this, they have set up the committee consisting of 6 members.
They have
And,
put representative from finance and law.
Finance and, yes, finance and law. Unless, when the service rules, it's very clear they cannot, unless it is amended. That is the position. Now, I'll take your lordship to the to the main page 60. Page 63. Lordship, page 63. This is the, I am aggrieved by this, the correction. Page 63, page 64 is the type copy. Page 64. Now, this correction, that is 4th of June. 4th of June 2025. This is to inform all concerned that in continuation to the advertisement number so and so, dated Singapore as 7th April 2025 and addendum so and so, dated 14th May 2025. The Departmental Recruitment Board decided, here the Departmental Recruitment Board arbitrarily decided to include written tests in the interview process for the post of 46 constables of excise in line with other uniformed services. So this corrigendum was issued arbitrarily by the board itself, no government. And then secondly, the settled principle of law that you cannot change the king halfway through the match.
What was the last date for submission of applications?
Supplication, it was pardon? Yes, but if your lordship may go to
30th April.
page 30, yes, it should be 30th of April 2025. Now, your lordship, since all these things were going on, no transparency at all, we submitted an RTI application requesting for all the necessary, even the file notings about the decisions that have gone on. And the application is at page 72. This is our application. We have sought for a copy of the service rules. This is dated 12th of June, page 72, annexure K, page 72. This is dated 12th June 2025. So we sought for by the two of the petitioners, petitioner 1 and 2 submitted this version. So we have sought for this copy of the existing service rules, copies of the past advertisements for similar recruitments published since 2016 up to date. 3, marking system consistently applied in selection in the past. Percentage of marks assigned for physical and so on. Number 4, the marking system to be applied in the present selection. Percentage of mark assigned for physical test, written test, and viva voce. 5, the copy of the entire file noting related to the present recruitment. So these were sought. Now on 2nd of July, this is annexure L, page 73. On 2nd of July 25, the reply was furnished to us. Now, RTI reply, page 75. If your lordship may go to the page 75. They have listed out the things which they are giving to us. And then page 4, paragraph 4, the marking system to be applied in the present selection, that is percentage of marks assigned for physical test, written test, and viva voce will be. Physical test is no markings, written test 100 marks, viva is 12. That is what is given here.
Okay.
Now, after that, all the copies were, the file notings and all, here officers have raised concerns, which at the time of the hearing, I'll take your lordship through. Raised about the concerns of all these things that have been, the board has been without, without considering the.
So you're aggrieved by the constitution of the board
Yes.
and then the inclusion of these written
Yes.
exam.
Yes, that is the, and then even the physical test, we submitted a representation highlighting all these irregularities. Because we.
But the
received-
main issues are these two,
Those are the two, and the third one is also physical test must be conducted in terms of the
in terms of that
memorandum.
notification.
Yes, memorandum.
Okay.
Now, they have watered it down to a few of this and then they are just formally say they are applying.
Mm.
So only what is now going on is
We will,
800 videos read
this
from
needs
Venezuela.
examination, will issue notice at this
Yes,
stage.
and then, Your Lordship, which is 2025. That this itself deals with the entire case, the case in its entirety. 2025 SCC. 2025 2 SCC. 1, page 1. I'll take Your Lordship to page. Page 36. Page 36.
Mm.
Oh, sorry, I'll take Your Lordship to page 37, the last conclusions.
Conclusions.
Yes.
Mm.
We therefore answer the reference in the following terms. 65.1. Recruitment process commences from the issuance of the advertisement calling for application and ends with filling up of vacancies. 65.2. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the external rules so permit, or the advertisement which is not contrary to the external rules so permit. Even if such change is permissible under the external rules or the advertisement, the change would have to meet the requirements of Article 14 of the Constitution and satisfy the test of non-arbitrarity. 65.5. The decision in K. Manjushri lays down good laws and is not in conflict with the decision in Subhash Chandra Marwa, so and so, so and so. 65.4. Recruitment bodies subject to the external rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus with the object sought to be achieved. Next, external rules having statutory force are binding on the recruiting body in terms of procedure and eligibility. However, where the rules are not existent or silent, administrative instructions may fill in the gap. Here, the administrative instruction is a memorandum for the physical case. 65, placement. So this is the general rule. You cannot change halfway through the, you cannot change the eligibility or the things halfway through the procedure. In short, the whole thing has been discussed in detail in this segment. So here they are acting in utter violation of the statute, that is the service rules, which clearly provides that one day and they are following another rule.
So physical tests will be completed today.
Today it will be
And-
completed.
And when is the written test?
Written will be in the month of August. In the month of August, it is. There is a,
Is who accepts notice?
My lord, with regard to the, if you look at the advertisement,
Yes.
page 30, it clearly says at para condition number 15. Any
Petition.
omission or commission will be rectified through notifications and addendum. Then 16, in the event of any disputes on recruitment process, the decision of the department recruitment board will be final and binding. And my learned friend, he has read out the recruitment process. That is para page 46, the recruitment rule 5. It talks about recruitment to the service after the commencement of this rule shall be of any of the following methods. 1, by direct recruitment through competitive examination selection. So if the rule itself provides that there will be a recruitment process through competitive examination. So the inclusion of the written exam is also permissible. And the rule is silent about the modality as to how the recruitment board is to conduct. When the rule is silent, the recruitment board has the power to prescribe the modalities in prescribing the written test. And he has referred even Rule 5 Clause 2.
Yes.
The opinion, Notwithstanding anything contained in sub-rule 1, if the opinion of the government, the exigency of the service so required, the government in consultation with the commission. Here, the commission is the NPSC. So with regard to the higher post, NPSC is required. But this excise constable, it falls outside the purview of NPSC as well as the NSSB. That's why the recruitment board is going to conduct the exam. So the recruitment board is their authority. My prayer is that
Because the service rule does not prescribe the modalities,
Yes.
like how to go about,
Yes.
whether it should be just written and oral, or whether it should be physical, written, viva, that
Yes.
nothing is said in the,
If the
in the.
it is for the government to do it.
no, it is the board. It should be the recruitment board.
Subsection 2, sub-rule 2 is very clear, Your Lordship. If anything is to be.
No.
Anything which is, if any changes are to be made.
This is only regarding the method of recruitment. Only regarding the method of recruitment.
Yes, but then, even in that case, the settled principle, they are now following a set way of recruitment. That is written and no, physical and
Physical and oral.
viva
Viva.
only.
Viva.
That is established already. Now, if anything, any changes to be made, it is by the government which must make it, not the board. The board has been set up only to conduct the interview. The board cannot make its own rules along the way. That is what I am saying. So, Your Lordship, if at all, if some in the process, the procedural aspects, for example, after everything is laid down and it is being followed, in that case where there are silence in the service rules, then in those cases, the board may, in order to give effect to the recruitment process, they may make some minor changes, but not in this way. Minor, they may
No,
employ
the
ways and means.
educational qualification is class 8 plus.
Class eight.
So, what apprehension do you have if there's a written test?
Some are class 8, some are graduates, some are master degrees. Now,
Anybody can
Yes,
be.
anybody can apply here. So now, by introducing this written examination, what is happening is, and then relaxing the physical. What they are doing is, they have relaxed the physical test to the minimum, so that.
Okay, we'll
Yes,
issue notice.
and then now, by introducing this written examination, some are only class 8. Some have read only up to class 9 or 10. How can they compete with this master degree, and even PhD holders are contesting here, Your Lordship. So equal, and having the written test is not subject, it is not an objective kind of test, it is subjective. Having the viva is more objective, because they can take the person's capability in the viva test. Even the Supreme Court has, in various judgments also.
Okay, right. The petitioners herein are aggrieved at the conduct of selection process of the excise constables in violation of Nagaland Excise Service Rules 1999, and the memorandum dated 19/7/2016, which prescribes minimum physical and medical standards for selection of all posts of field staff in the excise department. So, the petitioner is also aggrieved by the constitution of the Departmental Recruitment Board, which is against Rule 7 of the extant service rules. Stop. I have heard learned counsel for the petitioner, Mr. Tongpok Ponganer. Stop. The petitioner further submits that if petitioner has prayed for questioning and setting aside of the impugned letter number such and such, you just see from the prayer portion, okay? Letter number such and such dated 25/3/2025. comma, impugn notification number such and such dated 23/4/2025, comma, impugn corrigendum number such and such dated 4/6/2025, and the physical test being conducted in contravention of the memorandum dated 19/7/2016. Stop. The petitioner has also prayed for a direction to the state respondents to constitute the departmental selection board in consonance with the provisions of the rules of 1999. And to direct the state respondents to conduct the recruitment process strictly in terms of the advertisement dated 7/4/2025, and also to conduct the physical tests in terms of the standard laid down in the memorandum dated 19/7/2016. Stop. Learned additional AG V. Shukri has accepted notice on behalf of
All the
all
respondents.
the respondents, and hence no formal notice is called for. So the petitioner shall serve extra copies of the writ petition to the on the learned additional AG during the course of the day. Stop. Issue notice returnable within 4 weeks.
Lordship, I have an interim prayer.
For that interim prayer, I object.
Yes.
He cannot stall the process of the
Mm.
selection process when he could not make out a proper case.
Mm. The it is directed that we can consider on the next day, or
Your Lordship.
Or if this will be subject to the outcome of
If
the.
the written exam.
the interview process shall be subject to the outcome of this writ petition.
Your Lordship,
Yes,
if they may be made to reply at the earliest before
Yes, yes,
before the written exam is conducted, so that fairness is allowed. If they go on seeking time and the written exam, everything is conducted, then.
No, the
Yes,
urgency is
Your Lordship.
noted. The
Yes.
urgency is already noted, so
Then,
we'll see.
Your Lordship.
3 weeks then? 3 weeks?
Lordship, this should be subject to the outcome.
No, that I've
No,
already
yes,
said,
that's it.
it is subject to the outcome.
But-
No, to file your affidavit. 3 weeks.
3 weeks, okay.
The issue notice returnable within 3 weeks. Yes.
That's right.
From the supplementary cost list for motion, item number 27.
Such
Yeah,
a big
one
fat,
of
big
those-
fat petition.
One of those peculiar cases which happens only in our state. Another attempt by one tribe to dominate over another. And we are the unfortunate victims here.
Mm.
So in short, you should just few of the facts for the establishment of Walwang village.
Mm.
You can go to the body of the petition beginning from page 6.
Mm.
Paragraph 2, may I read my part?
Yes.
That Walwang village is a village inhabited by Kuki tribesmen. It is a recognized village. It's a very important statement, Your Lordship. It is a recognized village by notification dated 23/7/1970, by which the Constitution Scheduled Tribes Order 1970 was codified. The Kuki tribe is recognized as one of the scheduled tribes of Nagaland. Then paragraph 3, paragraph 4, at page 7, how the village was established.
Mm.
Late Kubjalit Kuki served in the Assam Rifles. He rose to the rank of Subedar. Late Kubjalit Kuki and late Vinizo Angami, the founder and GD of Benzipama village, were good friends. Now you all should see, Benzipama village was not a village that was in existence since centuries ago. It was about the same time.
Mhm.
Late Vinizo and late Kubjalit, they were contemporaries. Benzipama village was founded by him along with his followers from other villages. During the course of their friendship, late Kubjalit indicated his desire to set up a village for his people. Benzipama village at that time had only a few households, and late Vinizo Angami told late Kubjalit Kuki that he would establish his village on land near Benzipama village, and for that purpose, he should apply to the Deputy Commissioner of the Naga Hills. Given their friendship, late Kubjalit Kuki agreed and submitted a letter dated 10/5/1938. with the Deputy Commissioner Naga Hills for allotment of land between Janapani and Diffu rivers. Even the location of the land was mentioned. The annexure is there, page 2, not necessary to go through that. Then the process at paragraph 2 and paragraph 3 and paragraph 4.
Then the allotment,
Yes, paragraph 4. This is at page 57. At page 57. Page 57.
So Peter, such and such.
Yes. It will reach on page 57.
Yes,
This is
yes.
only case number 36 of 38.
Mm.
Subedar Jared Cookie is allowed to occupy the land for on the following conditions. Recipema are the rightful owners, and in recognition of this right, ₹2 will be paid yearly to the GB of Recipema, and the land will remain Recipema's in name. This is very important revision. So the recognition of Recipema is a nominal recognition, nothing more. No revenue will be paid. No revenue will be paid in 4041 or 4142. Thereafter, house tax from the occupants will be realized on the cookie scale. So house tax was also to be paid to the British Crown, to the Deputy Commissioner. No Nahor trees will be felled except for buildings erected on the land itself. In Jums, Nahor trees will remain intact. No extension of the area will be allowed. Doing on Razarima land is forbidden. So these are the terms on which the land was allotted to Jared Cookie for establishment of homes. Then the village was established in 1940. Village was established in 1940. All these years, no problems. Now, you ladies should recall, sometime in the early 90s, a campaign of atrocities against the Cookie tribe began.
Yes.
People were killed, villages were burned. In that scenario, in leadership, sometime in 1995, 2 Angami tribesmen were killed in somewhere in the Manipur side. Now, alleging that the Cookies were responsible, a quit notice was served to the Cookies living in the state of Nagaland. In this scenario, in year 1995, the Cookie tribesmen were made to sign 2 undertakings. Your not certain. So you will find that in page 101. Page 101. The first one is at page 101. The type copy is at page 103. We were summoned to a meeting in Misappropriation village. And in this meeting, we were compelled to sign 2 undertakings of the same day. May I read leadership?
Yes.
We, the undersigned leaders and elders of the Cookie community living in Chakro Ungami area, do hereby solemnly declare as follows: that the Cookie community living in Chakro area, such as those belonging to Molvom, Bumsang, Malva, Kaibong, Suri, Kaibijan village, and those living in Mesprima town, never collaborated in the alleged killing of 2 Angami brothers at Darfur village. We will do render all possible help in bringing dead bodies to the bereaved families. That we earnestly request the Angami Youth Organization to kindly revoke the quit not notice served on the Cookies living in Angami areas on humanitarian ground. So this is the first one. Then the next one is at page 105. And that copy at page 108. Yeah, read it.
Yes.
We, the undersigned GBs, chairman and leaders of Cookie community living in Chakwa Angami area, hereby made the following declaration at our own volition: that the present established 6 Cookies villages and those living in Metsipima town were permitted by the following Chakwa Angami's villages. Now, this is very important. You really should appreciate if we acknowledge someone as a parent figure in terms of villages, we are subservient to that village. Molvom village by Metsipima village. This is me. Molvom village by Metsipima village, and there are a number of other villages. Then, number 2, that in recognition of land ownership, we should continue to give proven rent annually to the respective village land owners as per the Angami Naga customary law, and should not sell the land now under occupation without the consent of the landowners. 3, that we solemnly pledge to respect and uphold the decisions of landowners, Chakra Public Organization, and should not go against the wishes of the Chakra Angamis, be it political or social. And in the event of any disputes or conflict within any aforesaid 50 villages or in any matter of land ruling, the Angami Naga custom law shall be made. Moreover, in due course of time, if situation demands, the landowners are at liberty to change the name of a village. Next page 109. That no fresh rookies community from other regions will be allowed to settle in the aforesaid villages, and to uphold this declaration, any committee authorized by Chakra Public Organization can check newcomers. That we solemnly tender a sincere apology to the Angamis in particular and the Nagas in general for the mistakes committed in the past. In future, we shall not be involved in any anti-Angami or anti-Naga activity. Further, we shall have no links of collaboration with other states. That in the event of failure to abide by the above state declarations by any Kuki individual, group or villages, the violators shall be expelled from the area in the interest of peace and tranquility, and to avoid any misunderstanding. Accordingly, we signed this declaration on the 31st day of July 1995 at Misappropriation. So we are reduced to beasts of burden. We are reduced to dominions. Now, after this, sometime in the year 1979, alleging that we had violated the terms of the agreement 1940, and you agreement. Let's remember, village filed a complaint to the deputy commissioner, saying that we had violated the terms of the agreement. Therefore, they wanted to eject us from our property, from one village. We protested, we objected, we contested. That application was never taken into consideration, it was rejected. Unfortunately, we don't have any records pertaining to that particular altercation between two places, except for the application filed by them. So which I have annexed at page 63.
The application given by Misappropriation village.
Yes. At page 63.
Yes.
And that copy is at page 65. Just the relevant portion at page 66. At page 66. The middle paragraph. It is therefore submitted that since Kuki does not himself bound to honor the condition of settlement between himself and Misappropriation on the other, we exercise the right of ownership as per conditions of settlement, and also an exercise of the customary laws based on local practices, hereby declare that Kuki or Malwan village, for not very legible in the original copy shown, of their own forfeited the right of benefits derived from conditions of settlement 1940. It is further prayed that the conditions of settlement reached between Kuki and Misappropriation on the other in the 1940 be declared immediately by your honor as no longer having the valid force of law. Steps should be taken by us to eject them from our land in accordance with the local customary laws on the which Malwan village was based. So this is something they tried in the year 1979. They were not successful. Then in the year sometime in 2023, sometime recently, very recently, exact age I do not really know it, but the land from the new railway line from Rangabahar to Suchang, yes. So that passes to Malwan village. We were compensated. Malwan village was compensated, no problem at all. In 2023, the state of Nagaland came up with the proposal to set up the so-called Nagaki incubation center.
Yes.
Nagaki incubations. So in this, for this purpose, the first notification was issued on page 180, page 179. Page 179. Page 179. This is dated 6th May 2024. Whereas, in pursuance to government letter number such and such, and in the opinion of the Deputy Commissioner of Kohima district, it is expedient and necessary to acquire land speedily for setting up Nagaki city at Chatti Valley under Misappropriation subdivision, Kohima district, Nagaland. Now, therefore, in pursuance of section 9 of the Nagaland Act of 1965, Deputy Commissioner of Kohima district is pleased to order the land as per the schedule below is an area of 330 hectares at Chatti Valley under Misappropriation subdivision of Kohima district shall be acquired. Area 330 acres. Description of the boundaries, you can kindly see this, between Malwan village and Chatti River. Just a general description. We don't know whose land it is. North, Malwan village, south, Chatti River, east, railway line, New Sokunuma village, west, Misappropriation village. Whose land is being taken? We don't know. Then the next annexure at page 180. Whereas an order has been passed to acquire for land described below in Chumgiba district for setting up a multi-city at Chate Valley and the municipal subdivision, etc., etc. Under subsection 1 of 9 of the Nagaland Act of 1965, dated 6/5/24. Now therefore, Deputy Commissioner of Chumgiba hereby give notice that claims to compensation in any for all interest in the land shall be received by the Deputy Commissioner within 10 days of the service of publication, as the case may be of this notice. Again, the leadership will see. Notice is further given that possession of the said land will be taken over by the Deputy Commissioner or any officer deputy by on his behalf on behalf under subsection 2 of section 9 of the Act of 2024. Description of the land, Chumgidima, subdivision, Menzihema, village, Molvom, New Sukunama, and Razihema, area 330 hectares, location, Chate Valley. Description of the boundaries, again, you will see between Molvom village and Chate River, north, Molvom village, south, Chate River, east, railway line, west, Razihema village. Now, the point of note, your leadership, is this. Certain provisions of the Acquisition Act has been mentioned. But just mention of the certain provision of the Act does not lend legitimacy to the actions of the issue. It must be. in
There's
terms
a
of the
there's a process.
Yes, there's a process. It must be in terms of the prescription of the Act, not as they please, just by referring to certain provisions of the Act. So, since the exact land of Molvom village, which is sought to be acquired, was not we did not respond. We don't know. Now, when this process started happening, Menzihema village entered into the picture and started claiming that Molvom land belongs to it. And they wanted to change the name of Molvom village to Menzihema village. The railway station, which was constructed on Molvom village land, which is named as Molvom station, they wanted to change it to Menzihema railway station. Now, in line with this, in line with their activities, recently they issued another summons to me, and you ladies will find that in page 208. And we watching the English got page 208, you see. This is 16/1/2025.
Yes. Notice to attend
Yes.
meeting.
To the chairman, Molvom Village Council, NGB, Chumgima, Nagaland. Subject, notice to attend meeting on 19th day of July 2025. With reference to the above cited subject, we would like to state that there will be a meeting at Menzihema Village Council Hall regarding Molvom village issue and other related matters on date 19/7/2025, time 7 AM. It is therefore, please take note and attend the said meeting on a aforesaid date for further necessary agreement. Now, apart from the contents of the letter, which appear innocuous, what business does one village have summoning another village? On the face of it, litigation. On the face of it. Is this not an act of intimidation? I replied to this, in response to this, I submitted a representation to the Deputy Commissioner, which is at page 209. This is dated 18/7/2025, and we are in leadership. We had submitted a representation here, so the references are representation dated 8/7/24, subject notice dated 16/7/25, issued by the Municipal Village Council to the GB Molvom Village and the chairman of the Village Council Molvom Village. Sir, in inviting your attention to the above subject, we beg to lay the following few lines for your kind consideration. By our earlier representation dated 8/7/24, we have written to the government about the circumstances of duress under which we remain to execute declarations dated 31/7/1995, 31/7/1995, and 29/7/2023. We have prayed that the said declarations be treated as null and void. We have also objected to the attempt to change the name of Molvom village and to further deny its right in relation to the Nagaki Intimidation City, as well as the Rangapahar Zubsa railway line. We enclose herewith a copy of our representation dated 8/7/24 and the aforementioned declarations for any references in relation 1 to 4. We have recently received a notice dated 16/7/25 from the Menzihema Village Council summoning us to a meeting at its council hall on 19/7/25 at 7 AM regarding Molvom village issue and other related matters. We have been told to take note and attend the said meeting on a aforesaid date for further necessary. A copy of the said notice is here close for your perusal. Molvom village has got no business, Menzihema village has got no business interfering in the business of Molvom village. The said village also does not have any authority to summon the GB and village council of Molvom village. Since the 1990s, Menzihema village and its associate organization have been attempting to browbeat Molvom village into submission. We have submitted representations in this regard, but thus far, the state machinery has afforded us no protection. In these circumstances, we request you to take appropriate action against Misappropriation village and to restrain the said village from issuing notices and or summons to us. We further pray that the said village also be restrained from interfering in the affairs of Morpham village. And we have also filed an FIR at page 211. Now, with this background, Your Ladyship, we go to the prayers in my petition. At page 25.
But your main grievance is regarding the acquisition, isn't it?
Yes,
The acquisition
acquisition.
process.
And they attempt to change the name of my village. Attempt to change in my village. And also we are praying for protection in leadership insofar as our lives and properties are concerned. Because the threat is a real threat. Your leadership can see that, discern that from the declarations which we have made to sign. So the prayer is leadership at page 35. One, wash and set aside letter dated NHL 36, page 194. So this is a letter which is written by the ADC Kohima, recommending that Morpham village, Morpham station be changed to Kohima station. This is the officer who is entrusted with the Kohima subdivision. And
Written to whom?
your leadership, we say at page 194. 194. It is written to the deputy commissioner, and from there it will go onwards to the state village. At page 194, it's dated 14 February 2025.
Request for changing the.
Request for changing the name Morpham station as Misappropriation station of Dimapur Kohima regarding. With reference to the subject cited above, I would like to provide few comments on the changing name from Morpham station to Misappropriation. Already, without any reference to us, I have already decided. Morpham village was established under Misappropriation village jurisdiction after Misappropriation village granted land to Subedar. Wrong. This is also a wrong statement. It was granted to us by the Deputy Commissioner of the Naga Hills. We paid tax to the Deputy Commissioner of Naga Hills. We paid nominal tax, recognition in name only to Misappropriation village. And as such, Morpham village has been paying annual total land tax to Misappropriation village till date. It is not land tax, just a total tax. Misappropriation village is one of the oldest villages. Till today, we are paying house tax to the government of Nagaland Litigation, not to Misappropriation village. Misappropriation village is one of the oldest villages under Misappropriation subdivision, and the Office of the Additional Deputy Commissioner, along with other important government offices and institutes, use Misappropriation for address and location purposes. Morpham railway station is also strategically located not far from Misappropriation town and other surrounding villages. Hence, the use of Misappropriation may increase the sense of ownership among those villages and the subdivision as well. Therefore, it is suggested that the name of railway station be changed in public interest and convenience from Morpham station to Misappropriation railway station or Misappropriation railway station back to Morpham. The intent is very clear. On my property, on my land, can someone come in and say that the name should be changed without any reference to me? Then the next letter is a notice dated 10/4/2025, which is at page 195. And this is a notice. Now, Your Ladyship, the point is this, as we were discussing earlier, Your Ladyship, no acquisition process, no award has been passed. No award has been passed. And this is what has been passed. This is a notice which has been issued by the Office of the Deputy Commissioner. This is dated 18 April 2025. This is for the information of all landowners whose land has been measured for acquisition to set up Nagaki in Petition City under Misappropriation subdivision, Jungima district, that documentation for disbursement of land compensation should be done as per the schedule given below. Now your name, your leadership will say the name. Misappropriation Morpham.
Whose land has been measured?
Yes,
So.
we don't know. We don't know. No acquisition, we have refused to participate. We are saying, we have told the authorities, Morpham village land, you cannot change your name to Misappropriation. We have told the authorities, if you want to acquire land from Morpham village, you do it in accordance with law. With whom they are doing these things, we don't know, Your Ladyship. And in the process, the name of Morpham village is being changed to Misappropriation Morpham. Then, next prayer at B. Direct the state respondents as well as the Indian respondents to take appropriate measures. Direct the state respondents as well as the Indian respondents to take appropriate measures to protect the lives and properties of Morpham village. 2. Direct the state respondents to follow the procedure prescribed by law for acquiring the land of Morpham village. 3. Direct Union and the States Council not to change the name of Morvam Village and on the railway station of Morvam Village and from Morvam Village and Morvam Station to any other name. And in the interim prayer, which I'm asking for your leadership, in the interim pending disposal of the petition, be pleased to direct the state respondents, more particularly the respondents numbers 1 to 7. Now, here the response number 7, your leadership, is the Methikama Village Council. And your leadership will appreciate the village council is also an authority of law. To ensure that the lives and properties of the petitioners are protected, and further that the names of Morvam Village and the Morvam Village Station shall not be changed. Now, there is another very interesting point here, your leadership. There is a notification. Page 205, 204. Page 204. There is a long-standing instruction, and this is also in tune with the central government's policy on the criteria which is required to be fulfilled for change of names of villages, towns, etc., etc. This is dated 4 December 1998, and that copy is in page 206. Page 206. This is 4th December 1998. In supersession of this department's letter of unit number dated 5/94, change of names of villages, towns, etc. Without the approval of Government of India, Ministry of Home Affairs is creating confusion in maintenance of records with various agencies under central state government. The Governor of Nagaland is therefore pleased to notify that henceforth, prior approval of Government of India and Ministry of Home Affairs shall be obtained for change of name of villages, towns in Nagaland. All administrative officers should therefore strictly follow the following criteria while recommending cases for change of names, villages, towns, etc. The annexures of criteria is enclosed. Next page, Bishop. Unless there is some very special reason, it is not desired to change a name which have got used to for years. I don't want to change my name. Someone is compelling to change my name. And the state is an active party to this regulation. 2, name of villages, towns, etc., having a historical connection should not be changed as far as possible. Morvam village is a village of the Kuki tribe. I don't want it to be changed to an Angami name relation. A change should not be made merely on grounds of local patriotism or for linguistic reason. Example, villages, towns, etc., should not be renamed after national leaders merely to show respect to them.
But you are clubbing up two matters here, isn't it?
Yes, Amish.
One is that acquisition matter and one is this change of name and all that.
Because it is linked, Amish. Because insofar as
How is it linked?
because now the Betsipama village land. No, Bonbon village is now being named as Betsipama Bonbon. As in the previous notice at page
Oh,
at page 195. At page 195. As a logic, it got
the notice, the
Yes.
notice.
So it is said
As per the-
bracket Bonbon.
Okay.
They have already decided the relation. They have already decided.
Disappearing state respondents. Who's accepted here? Metsipima and Molvom are two different villages. So how in the notice is given Metsipima, Molvom like that? That it cannot be done.
Lordship, at least there's no disclosure.
Yes, of course, notice will be.
And even if may I show you or one more document in each.
Yes,
At page 180, page 180.
180,
Yes,
181.
181. This is a notice where villages were invited for the purposes of the Nagaki Intimidation. The tag copy is at page 182.
Yes.
Now, the meeting is hereby convened, 31st May 2024. The meeting is hereby convened in the conference hall of the Office of the Deputy Commissioner Tribunal on 5th June 2024 at 1 p.m. to discuss matters related to the proposed Nagaki at Chatai village, Metsipima subdivision, Chumjima with the following organization village councils mentioned below. 1. Now, this is what is important to your leadership, and this is something that really hurts us people.
Hmm.
The president of the Unmember Public Organization. What role does the tribal organization have to play in the acquisition of land for the Nagaki Incubation City
Hmm.
or for setting up the Nagaki Incubation City? Two, the president and colleagues, Chakrama Public Organization. Then, of course, the other villages. These are within the villages where the Nagaki Incubation City will be set up.
Hmm.
But what role does a tribal organization have to play in the setting up of this incubation city? We objected.
Hmm.
And because we objected, nothing concrete came out of this motion,
Okay.
out of this meeting.
Hmm.
Then we said that the setting up of Nagaki Incubation City should not be made a tribal issue.
Hmm.
Then next meeting again, another meeting was convened on 8 July 2024, and the list of persons who were invited at page 184. Again, you really should see the first column, Medzipema bracket Molvo.
No.
I've already decided.
Hmm.
We have already decided. So we objected against all this. Our objections have fallen on deaf ears. That is our case occasion. And in the process, an attempt is still being made to browbeat us into submission. As your leadership can see with the last notice which was given to us.
And under this Metsipima Molvom, any of your villagers are there, your names.
These are all persons who have bought land within our village. And person is number 11,
Hmm.
Alet GB Molvom.
Okay, GP Molvom. Hmm. Heard learned counsel for the petitioner, Mr. A. Zimomi. Stop. In the present application, the petitioner is aggrieved by the letter number such and such dated 14/2/2025, written by the Additional Deputy Commissioner Metsipema, recommending the name of Molvom Station to be changed to Metsipima Railway Station or Metsipima Railway Station, Molvom, under bracket, comma. The notice number such and such dated 10/4/2025, issued by the Office of the Deputy Commissioner, Deputy Commissioner Chumukudima,
Yes, sir.
to Deputy
Yes.
Commissioner Chumukudima for the acquisition of land for Nagaki Incubation City.
This is no compensation or anything. We're not doing acquisition anymore. Come for compensation, is what it says.
But then, anyway, we'll clarify later. For acquisition/compensation of land for Nagaki Incubation City. Stop. It is the case of the petitioner that the Molvom village was formed in the year 1940 when one late Kupjalet Khubjalet Kuki was allotted land by the then Deputy Commissioner by an order dated 18/1/1940. Stop. The said order directed the late Kuplajet Kuki to pay ₹2 to the GB of Mitsipima village annually, and that the land will remain Mitsipima's in name only. Stop. From the inception and even after statehood, the Molvom village has been an independent village and is a recognized village under the Nagaland Village and Area Councils Act 1978. Stop. However, by the impugn orders, stop, then you come to next paragraph. It is also submitted that in the year, when did it start, this acquisition process?
The process started in 23. 2023.
26.
Otherwise, the first notice was at page 179,
Yes, the notice 179, nah?
6 May,
Yes.
page 179. Discussions went on before that, but.
No, no, the official notice. Yes.
179.
Yes. That sometime in the year 2023, the process for acquisition of land for setting up of Nagaki city at Chatti Valley under Metsipima subdivision was started by the government of Nagaland. Stop. By an order under subsection 1 of section 9, dated 6th May 2024, the Deputy Commissioner of Chumukudima, Nagaland, issued a notification, issued the order stating that the schedule stating that the land as per the schedule below, measuring an area of 330 hectare at Chatti Valley under Metsipima subdivision of Chumukudima district shall be acquired. And then you just reproduce this portion, okay? This is page 179, schedule of the land, this whole thing. Stop. Thereafter, another notice under subsection 2 of section 9 of the Nagaland Land Acquisition and Requisition and Acquisition Act 1965 was passed by the Deputy Commissioner Chumukudima on 6th May 2024.
Same day.
Oh, same day. On the same day, showing the description of the land, giving notice that possession of the said land will be taken over by the Deputy Commissioner or any officer deputed by him on his behalf under Section 2 of Section 9 of the Act on 17/5/2024. Stop. It is the further contention of the petitioner that this process of acquisition is against the provisions of the Nagaland Acquisition and Requisition Act. Requisition and Acquisition Act 1965 as the process to be followed under the said act has not been followed by the state respondents. Stop. Accordingly, the petitioner has prayed for quashing and setting aside of the letter number such and such dated 14/2/2025 and the notice dated notice number such and such dated 10/4/2025. This you see from the prayer portion. Okay. The petitioner has also prayed for a direction to the state respondents as well as the union respondents to take appropriate measures to protect the lives and properties of Molvom village. Acha, who are the respondents you have made?
7 of the state. 7 of the state. And then 8, 9 are the Union of India, 10 is the Province Frontier.
You have implemented the Misappropriation Village Council also,
Yes.
na? To protect the lives and properties of Molvom village and to direct the state respondents to follow the procedure prescribed by law for acquiring the land of Molvom village. And also for a direction to the union and state respondents not to change the name of Molvom village and / or the railway station from Molvom village from Molvom village to any other name. Stop. Issue notice returnable within 4 weeks. Stop. The learned government advocate, MS Bichano Kitan, has accepted notice on behalf of the respondents 1 to 6 union. Anyone has accepted?
Who that is sending government council of this, but I'll find out.
Served, okay. Who accepted? We can,
Where is answered by? Otherwise,
no,
I'll serve.
I don't think they can accept. So the learned counsel for the petitioner shall take steps for service of notice on the respondents number 7 to 10 by registered post, as well as usual process within a period of 3 working days from today. Stop. In the interim, the state respondents, particularly respondents number 1 to 7, are directed to ensure that the properties of the petitioners, the land and properties of the petitioner,
Lives and property.
the lives and properties of the petitioner is protected, and that the name of Movum Village and the Movum Village Station shall not be changed till the next returnable date.
For admission, item numbers 6 and 7.
Affidavit filed.
Your Lordship, like, we are actually waiting for dating, however, Your Lordship, by the last order. Is we are. However, it's almost the same, Your Lordship, we are saying, the amount is, it's an admitted liability. However, we are saying that when the work, order was issued, Your Lordship, payment.
Oh,
will
this
be
is
made-
regarding payment of penny
Yes,
bills.
yes, yes. So when the workload order was passed, Your Lordship,
Mm.
it is mentioned that like as and when the fund is available, Your Lordship.
Oh,
So Your Lordship, so far the fund was not available and like it was not sanctioned. That's why Your Lordship, we could not able to release the amount. That is the position of the state government, Your Lordship.
Lordship, in this regard, how they have issued the work order when there was no money?
Also instructions to how much time will be required to pay the pending bills.
So Your Lordship, at least
Lordship,
6 months may be granted to us.
So that I have completed the work with that in
Hmm.
It doesn't.
2000. I have completed the work in
19.
2019.
Only after funds are made available, the work orders are issued.
Yes, however, Your
Always.
Lordship, if you can kindly come to
Mm.
page 11 and next year of the writ petition, Your Lordship.
Page 11,
Yes, Your Lordship. page
work
11.
order.
Yes, Your Lord- on the last line, Your Lordship.
Hmm.
Payment will be made only as and when the fund is available, made available by the government, Your Lordship. So
So
because
if
of this
if it is
reason.
stated
Your
that
Lordship-
money is not available, then I have to wait for 100 years, Lordship.
So Your Lordship, that's why Your Lordship, we are also making an endeavor. So at least considerable time may be granted to us so that the government can also take steps to make payment, you know, because even otherwise the amount is a.
It's a,
liability.
but it's a small amount.
Yes, I agree. How do you?
2 lakhs 54,000.
They have crores of rupees to organize a festival.
Ah,
They don't have 2 lakhs to pay my bill.
Which is,
No,
some
no,
time may
no,
be
no,
granted,
no,
Your Lordship.
no, no, we give you only 1 month's time.
Your Lordship, that will be very minimal, Your Lordship. Yes, about 3 months.
You
Your
are just
Lordship.
from somewhere, 2 lakhs 54, they can always adjust. What,
Your-
such a big department.
Your Lordship.
It's
at this
PWD, isn't it?
Current,
Yeah.
oh,
There are petitions for it. One is amounting to 6 lakhs 20,
Hmm,
and one is 2 lakh 54.
hmm.
Lordship, it's not even coming to 10 lakhs.
so at least 3 months, Your Lordship, so that like, in order to avoid contact. Your
Lordship,
Lordship.
I've completed the work back in 2019.
Hmm.
From 19 to 2025, Lordship. 6 years. In 6 years, they have spent thousands of crores. in other activities, entertainment, where I have built a quarter for the police. They are not-
Quarters.
Yes,
Mm.
quarters. And police, they have accommodated, they are occupying the quarters. I have not blocked the quarters, unlike the other contractors also.
Your lordship may be
Yes.
gracious to grant at least 3 months, your lordship.
No, Lordship, I have
Your
not.
lordship,
Yes,
otherwise, your
it was-
lordship, the current position is that, your lordship, we are also making an endeavor to make it the payment,
Lordship,
so
it's-
at least
Total is
accommodate
8
your
lakh
lordship.
74,000, 8 lakh 74,000, Lordship.
Heard learned counsel for the petitioner, Mr. N. Muzwe. Stop. The present case arises out of non-payment of the petitioner's pending bills. Stop. It is stated that the petitioner is a government-registered electrical contractor having registration number CEL/CON/062 under the government of Nagaland and carries out electrical construction works all over the state of Nagaland. Stop. By work order dated 16/7/2019, the petitioner was allotted construction works of type 1 quarter at 7th NEP Battalion Bandari under TFC 2014-15, open bracket, construction of SP type 6,
Type 6.
type 6
CO.
PO's quarters at Bandari, close bracket. Along with site development, water supply, water supply, sanitary installation, and rainwater harvesting, amounting to rupees 2,54,753 to be completed within 6 months. Stop. The petitioner completed the work within the stipulated time, and the work was verified and inspected by the concerned authorities. Stop. Thereafter, completion certificate dated 31/5/2019 was issued to this effect. Stop. However, till date, the petitioner has not been paid the pending bills. Stop. Being aggrieved, the petitioner is before this court. Stop. Para. On 18/3/2025, this court had directed the learned government advocate to come with proper instructions as to whether the petitioner has undertaken the construction work in question, and if so, why the bill, and if yes, why the bill in question for construction has not been released to the petitioner. Stop. It was also directed that necessary orders will be passed on the next returnable date. Stop. Thereafter, on 11/4/2025, when this present matter was listed, the learned government advocate appearing for the state respondents submitted that the case of the petitioner is under consideration and further time was sought. Stop. It was also directed that the learned government advocate would apprise the court about the status of payment of admitted liability payable to the petitioner, failing which the court would pass necessary orders. Stop. Again, on 15/5/2025, the learned government advocate prayed for 3 weeks' time to obtain the status of the pending bills to be paid to the petitioner. Stop. This court directed that if no instructions are received and the matter is an admitted liability, the court would dispose of the petition at the admission stage. Stop.
7 times there.
Yes, yes. On, on 9/6/2025, the learned government advocate again sought for more time to get instructions. Stop. Today, when the matter is called, learned government advocate has submitted that the liability is not disputed and the matter is being processed for payment, and therefore the state respondents may be given 6 months' time to make the necessary payments to the petitioner. Stop.
Yeah, my lord,
Para.
by submission on the pay, on the work,
Acha, acha.
that will also be reflected.
Before that, or after that, you say, learned government advocate also submits that in the work order, it is specifically stated that the payment will be made only as and when the fund is available, only when the fund is made available by the government.
And because of this, we are unable to pay some CASPA. That is the submission. However,
And-
endeavor
and-
is being made.
And due to which the payment has not been released as the funds were not made available by the government, comma, however, efforts are being made to release the said payment. Stop. Para. The court has considered the submissions of the counsels for the parties and have perused the records, perused the pleadings. So it has been noticed that the work order is of 16th July 2018, and the petitioner had already completed the work on 31/5/2019. Stop. It is now, so how many years? 19, 20, 21, 22, 23, 6 years. It is now 6 years since the petitioner had completed the said work. However, the state respondents are yet to release the payments due to him. Stop. It is also seen that the pending bill is not a big amount, as it is only an amount of rupees 2,54,753. Stop. In view of the above facts and circumstances, comma, the petition is disposed of with a direction to the state respondents to release the payment of rupees 2,53,000. No, wait, to release the pending bill of rupees 2,54,753 to the petitioner within a period of 2 months.
2 months.
2 months.
No, within a period of 2 months from the date of receipt of this one.
The next item, similar, just the work order, the amount. Competition is also different.
Okay, this WBC 292.
292,
Okay,
yes.
the first one is this is 291, then 292.
The work order is dated.
Similar order, but only the work order will be different.
Yes.
So here, the work order is,
Paragraph 4. Work order at paragraph 4 also.
you just check out from here. Okay.
Paragraph
No, which annexure?
Annexure A. There are only 2 annexures, A
Okay.
and B.
So the work order is at annexure A,
A.
order dated 20th April 2018, okay, in WPC 292. And here also 2 months. But the work, nature of the work is different, isn't it? The other one was,
Yes.
yes,
Yes.
here you say this, earlier we said it was for construction of this and
Yes.
that, no? So
Internal
this one will be,
internal
uh,
allocation. Internal allocation.
where have you stated in the writ petition?
Noted in annexure A.
Okay,
in
well,
annexure A.
this, No, we'll just go to the synopsis.
Annexure A, the work order will speak, Lordship. Subject, construction of so under bracket, internal electrification. In the subject, Lordship.
For construction of RCC type 3,
G plus
G+1,
4 flat for
4 flats for staff quarter at 7th NAP,
Bandari
Battalion Bandari,
under MOD.
under MOT 215-16, under bracket, internal electrification, close bracket, then amounting to rupees 6,20,200.
The government want us to build they can't pay us. They're at the mercy of the contractors, Lordship. The government is running at the mercy of the contractors.
Yes.
Obliged, Lordship.
Okay. We'll just come back after 5 minutes.
Lordship.
For admissions, item number 11.
Anyone? Item 11. This is also Moses' case.
Lot.
He was just here. Counter filed.
Lot.
Yes.
If this matter may come up after the Mr. Petal,
Okay. Call after some time, no? Then after some time.
the pledge lodge.
Yes.
For admission, item number 13.
Item 13. You're there? Yes.
May I place your lordship?
Hmm.
Your lordship, in regard to this matter, I've filed this to give operating order issued by the state.
Hmm.
Now, my lord, the paragraphs of the report,
Hmm.
the environment,
Hmm.
I the ones that you immediately for.
Hmm.
Now, lordship, in the eye, they invite some vitamin protection.
Hmm.
In regard to the negativity of this application.
Hmm.
Now, my lord, in your, I want to, with all the property,
Hmm.
your main condition was that, since the petitioners have not financially,
Hmm.
issued by the special secretary
Hmm.
for the approval of the petitioner.
Hmm.
So on that ground, we have filed a mandatory of the petition.
Hmm.
Now, my lord, in regards to that, I filed the objection.
Hmm.
Now, in the objection, I already stated that since the administrative approval, this is a communication between the departments. Most it was not legally available
Hmm.
during the time of filing of this litigation. Moreover, my lord, in Nagaland practically, the state is the administrative approval, since it is just a communication between the department.
Hmm.
It was not with the person concerned.
Hmm.
Only to final order, that is the appointment order which has been established in the petition.
Hmm.
It was given to the person concerned.
Hmm.
So, my lord, if the appointment order, since that is the final order,
Hmm.
it should be squashed in the administrative approval, it will become invalid. However, my lord, in regard to that, I was directed by this honorable board to
Hmm.
file an amendment application.
Hmm.
And portray today to give administrative approval.
Hmm.
By what we dated 25/3/2025, which I've already annexed in my I 42/2/25 at page 8 I 42.
I 43.
Yes, yes.
Hmm.
I 42/2/25.
Hmm.
That is in page 8 document.
A 43 of 2025. Yes.
Yes.
2 weeks time to file an amendment application incorporating the impugn approval order. Okay, then after that you file this.
Yes, but in view of that, I already trustee for incorporating the administrative approval
Hmm.
as directed by this law.
That was allowed.
Yes,
Allowed.
Regard on that,
Hmm.
the private respondent had filed a objection
Hmm.
stating that it was not in the proper format
Hmm.
for incorporating the administrative approval. So.
No, after the court allows this IA, then you'll have to file an amended petition.
Yes,
Yes. So amended petition filed.
yes, I filed by way of
No, not by way of IA.
Yes, incorporating the administrative approval.
No.
In that, they filed.
See, the court will have to pass an order allowing your IA, okay, allowing you to file. Hmm. So was any order passed by this court allowing the amendment?
No, Lord.
No.
Lordship, here from that, I've already filed the incorporating the administrative approval.
No. Have you filed an amended petition incorporating that? And then in the prayer portion also, everything you have to amend,
No, Lordship.
that hasn't been done.
I filed by way of I. So
No,
Given the.
that will not do.
File the regards petition.
Let's see your prayer. Let's see your prayer in the IA. Maybe please to pass an order for incorporating the administrative. We just pending. Okay, we'll do this. We'll just pass an order in this IA allowing you to file an amended petition.
Lordship, in that
Ah,
respect,
Yes.
I filed an objection
Mm,
saying that though this honorable court by order dated 25/3/2025
mm,
was pleased enough to allow the
mm,
petitioner
mm.
to file necessary petition for
Mm.
amending the writ petition.
Yes.
So the petitioner
Mm,
by IA 43
Mm.
has filed the IA
mm.
not for amending, but for incorporating. Or she may come to page number 2 of the IA. In the course title also.
Mm.
An
An
application for
application.
incorporating the Indian administrative approval order dated so and so 13 November 2023 issued by the Deputy Secretary of to the Government of Nagaland to the Director Rural Development Services. IA for amendment should be filed in such a way that specifically the petitioner should specify the
Which
paragraph,
prayer portion, how to
portion,
change like
title,
that, all those.
all those. So in the petition, it was not done so.
Mm.
Only this
Yes,
saying that to
yes.
incorporate the administrative approval for appointment of the NPS
Mm.
in aspect of the response number 5. So that is at page number 9. But the lordship may come to my.
Yeah. I got the point. Mm.
I filed my.
So this will not do. This IA will not do.
Yes, Lordship. My prayer is that, since almost all the pleadings are completed, so I will be given the opportunity to file my regards petition by incorporating the
No,
Lordship-
first you have to file an IA showing the court which paras you want to amend and how you want to amend the prayer portion. Then only then the court will again allow you to file the recast petition. Okay. So, yes,
Lordship, I file an objection
yeah,
for
you,
disputing
you,
this
you withdraw this then.
IA.
Mm.
the I.
Or else,
Because on technicalities, I don't want
Yes.
to, yeah.
or else without even going to the incorporating all this,
Yes,
we
yes.
can directly
Yes.
dispose of the writ petition.
Lordship,
In fact, Lordship,
I may
But
be allowed to
again-
withdraw the I. In the meantime, I'll be filing the for necessary for amendment.
Short time,
Yes.
1 week.
Okay,
Mm. In IA 43 of 2025, okay. Learned counsel for the petitioner, Mr. Tushi Tamjin, counsel for the petitioner / applicant, Mr. Tushi Tamjin has prayed for withdrawal of the present IA as there are some errors, just say as there are some errors in the same here, and he prays also for a liberty to file afresh. Stop. Prayer is allowed. The learned counsel, the learned counsel is allowed to withdraw the IA. Stop. Liberty to file afresh. The petitioners, in view of the long pendency of the writ petition, in view of the long pendency of the connected writ petition, the petitioner shall file the same within a period of 1 week.
Lordship, in the meantime, interim. Here's an interim.
Oh, the interim order passed in the main petition,
in the writ.
in writ appeal, writ petition 269 of 2023 shall continue till the next date. This is what, landowner?
Yes, Lordship. Appointment on land.
What?
For admission, item number 11.
Item 11.
Lordship, this is the second round of litigation, Lordship. We have earlier approached this honorable court by filing a writ petition challenging the suspension of the village council by the deputy commissioner. Now, during the pendency of the writ petition, the early writ petition, Lordship, that is the PC number 48 of 2024, this honorable court made some observation whether under the Village Council Act, the deputy commissioner has the power to suspend the village council. Because as per the act, it's only the government who can do it. Now, a certain query was put up to the government advocate to seek instruction. So the response was in negative. No, deputy commissioner doesn't have the power. Now, the matter was adjourned and fixed for hearing. During that intervening period, they have immediately issued the order dissolving the village council.
By the government.
By the government now, to cover up their illegal orders. Now, by this writ petition, Lordship, we are challenging the impugned order dissolving the village council on 10/1/2025, Lordship. Now here, the brief facts, Lordship. We were duly elected and selected village council member. And in view of the direction of the government, in a nutshell, Lordship, if I go into the documents, we were duly constituted village council. As per the government order, Lordship. We've been elected as village council and we worked for only 9 months. Then an allegation was made against us that there's question of misappropriation, not functioning properly. We don't hold village council meetings. So a complaint was made by the frontal organization of the village, like the women organization, the youth organizations, the student organization. Immediately on receipt of the complaint, the deputy commissioner has suspended the village council and taken over the village council, the administration. Now, during the pendency, we filed a writ petition challenging our suspension because though there was an order that an inquiry will be conducted, no inquiry was conducted. Then the validity of the suspension order was taken up by this court, as I've earlier mentioned, whether the deputy commissioner has got the power. Immediately they have dissolved our village council. So that is the crux of the matter. Now, Lordship, if I may, Lordship, may I be allowed to come to the documents, Lordship?
So what is your prayer here is against the dissolution?
Against the dissolution, besides other orders, Lordship, other impugned orders, because there are some consequential orders, how the impugned order has been issued, Lordship. So I'm challenging the impugned order dated 31/5/2022, temporarily suspending the village council. Then the impugned order dated 26/7/2022, directed the petitioner to hand over all the records of the village. And the impugned notification dated 20/12/2022, where the deputy commissioner has taken over the activities. Besides that, the impugned order dated 19/11/2024, annexure N, I'll come sequence, Lordship. Then 10/11/2025, annexure Q. That is the impugned, the main dissolving the village council. If Lordship might be allowed to go in sequence. Lordship, may I kindly come to annexure A. This is the circular issued by the EAC, Chumukitima. Lordship, one aspect of matter, Chumukitima was under Dimapur district.
Yes.
At that point of time, when the village council. Now it's a different district. So the Chumukitima EAC has issued a circular on 15 April 2021 for constitution of the village council, as per the Village Council Act, Section 4, Lordship. Lordship is aware of the Section 4 of the Act, Lordship. Now,
anyway, if you have an extra copy of the act, back just Nagaland Court, Nagaland Court.
Lordship,
Yes.
having the second edition
Yes, this is the second edition.
Yes.
Page,
Lordship, may kindly come to page 62. Section 4. Section 4, Lordship.
okay.
A village council shall consist of members chosen by the villagers in accordance with the prevailing customary practices and usage, the same being approved by the state government, provided that the second part is not applicable to us, the heritage regulation. Now, in view of the circular issued, the head GB has forwarded the list of name of the village council. Lordship, may kindly come to page 24.
The new village council.
Yes, 24, page 24. There's no date, Lordship, but this is a letter written by.
Tenure is 5 years, na?
5 years. So my tenure will get over next year.
Okay.
So till page 25 is a meeting by news, Lordship. This is how we have been selected and elected. Our name has been forwarded. Page 25, Lordship. Now, Lordship, I'm not using the whole document, the list of the approved members, but the proportion where I've been approved, Lordship, it's page 26.
These are not disputed.
Not disputed. But Lordship, here the issue has been raised by the frontal organization that we have not been properly elected. So, yes, but the fact is not disputed. This fact is not disputed because government has approved us as per section 4. As per section 4, we have been duly approved by the government. So, under such circumstances, no formal order is required. Separate order approving our name. It comes in common. So, my village is serial number 29, Lordship, page 26. The list of the village council. There are 16 of us, Lordship, altogether.
Serial number 29.
Yes.
Tolozuma.
Yes. Tolozuma.
So this was forwarded.
Yes, this was
So
government approved. Already approved. So we are duly elected member of the village council in terms of section 4, Lordship. Now, any action to be initiated for non-functioning misappropriation has to be in accordance with the Village Council Act. So whether the issue is now, Lordship, whether the government has acted in accordance with the provision of the Village Council Act. Now,
So
Lordship,
what is annexure B?
Lordship?
Annexure B is.
Annexure B is this for the chairman.
Okay.
So chairman election comes under section 7. The village council will choose a member as chairman of the village council. So, serial number 13, annexure B. We have duly elected our chairman. And this has been notified. The Deputy Commissioner Dimapur has issued the order. Now, the issue comes.
Then.
Yes. Now, Lordship, may kindly see, we officially started functioning after the chairman. That is August 2021. Lordship, this date may be noted, Lordship.
August 2021.
19 August 2021. Yes. So immediately after resuming our office as village council member, the frontal organization has issued a complaint on 23/6/2022.
This annexure C.
Annexure C, yes, to the Deputy Commissioner. Lordship, if I may be allowed to read. To the Deputy Commissioner, Chumukitima. Now they are already a full-fledged district now though. Submission of resolution adopted during public meeting of Tolozuma village on 21/5/2022. These are all unconstitutional bodies, not a recognized registered bodies, Lordship. They are the frontal organization of the village. With reference to the above, the 5 frontal organization of Tolozuma village, that is Tolozuma Student Union, Tolozuma Youth Organization, Tolozuma Women's Organization, Welfare Group, and Tenime Welfare Union, Tolozuma convene a public meeting on 21/5/2022 22 at Government Primary School, Tolozuma, and deliberated on various issues, including the issue intimated to your office by letter under reference. In the meeting, the public unanimously mandate and resolved to adopt 4-point which is enclosed herewith for your information and necessary action. As per the resolution adopted, the funded organization would like to impress upon the following point for your immediate action. 1. To immediately accept and notify the resignation of C. Nitsezo Vener Head GB, Sri Nipete There, Chairman Village Council, who tendered the resignation on 21/3/2022 on moral ground. This is not true, Lordship. I'll explain to that, Lordship. To immediately nominate a committee to take stock of the village administration. Whether under the village council, there's a provision to constitute a committee to take over the village council. Only the administration can take over, Lordship. 3, to immediately dissolve the remaining village council members, GBs, PDB members, and various village board council members nominated by the government till they are democratically elected and mandated by the village public. See, Lordship. This is where I'm saying, when my election has been in accordance with the Village Council Act and duly approved by the government, how can a frontal organization, an unauthorized organization, come and say that we are not elected in terms of the act? Number 4, to set up a committee to audit all village board council nominated by the government in respect of receipt, utilization of village fund, and revenues received deposited. Now, this is one of the aspects of the matter, where the deputy commissioner has suspended us and subsequently they have dissolved us on this ground also, that we have misappropriated. We have not served for not even 9 months, Lordship. Then alleging that we have misappropriated more than crores of
But
rupees.
there's a process for
Yes.
removal.
Yes. The representative of the funded organization are constrained to place on record that no action has been initiated on the earlier representation under reference submitted to your office, and that we are compelled to request your authority to implement the above point within 14 days. Now, an organization is giving an ultimatum to the government. And the government has come under the pressure of this funded organization and they have acted, Lordship.
Then they should this annexure 10, annexure
Yes.
B.
They submitted the representation on at 23/5/2022, 23rd of May, and the impugn suspension order was issued on 31st May 2022. Immediately, within a span of 7 days. Now, the validity of this impugn order was challenged in the early writ petition motion, 48 of 2024. Now, thereafter, Lordship, the manner in which this frontal organization are functioning, Lordship, in the village. Lordship, may kindly come to annexure E, page 32. To the Sub-Inspector, Food and Civil Supplies. Nomination of volunteers for distribution of PHS and PMGKY ration. An organization writing to the government to take over the distribution of rations. Village are given rices, Lordship, under subsidized rate. So this is how they are functioning. This is one of the organization, Tenime Welfare Union. Lordship, I kindly come to the next annexure F, page 33. On the application of the Tenime Welfare Union on 2/6/2022, the Assistant Director, Food and Civil Supplies, has written to the Director, Lordship, this is how the government is also functioning. To the Director, Food and Civil Supplies, Nagaland, Dimapur, forwarding of application in respect of Tenime Welfare Union, Tolozuma. Madam, with reference to the above cited subject, I have the honor to forward herewith the application in receipt from the convener, Tenime Welfare Union, Tolozuma, in regard to nomination of volunteers for distribution of PHS and PMJKY, Russian in respect of MS Tolozuma Village Council, FPS stating that the village council is non-functional due to issue within the village council and has affected the distribution of food grains. Now, under such circumstances, the village administration comes into the picture, Lordship. But they are taking over the functions of the government. Therefore, it is entrusted that Sri Veshapa and Sri D. Shailesh, till such time the matter is resolved. Therefore, kindly change the FPS nominee of the above mentioned FPS to the entrusted person. Lordship, the banner, how they are functioning. Now, Lordship, may kindly come to.
Actually, district administration has to take care. If
Yes,
at all,
yes,
the village council is under suspicion.
yes. Now, another letter was written by,
And again, for interim village management also,
this
to
is
the ESC.
26/2022, written to the EAC by the Technical Welfare Union again.
Mm.
Nomination of interim village management committee. Lordship. So the government is totally at the mercy of these organizations.
Mm.
They're scared. They're scared. The government is scared of an organization. They are giving the names interim committee for village administration.
Mm.
Now, Lordship, in the month of July,
Mm.
we were suspended on 31st May.
Yes.
After 2 months,
Mm.
the EAC has issued an order. This is 26 July 2022, Lordship.
Mm.
Caretaker taking over the village
Mm.
council by the administration.
Mm.
Lordship, I mean, if I may be allowed to read.
Mm. Therefore, it is directed
or
that
the-
all the registers,
where-
records, cash books relating to.
Yes,
Okay, calling for the records.
all the records.
From
All the records has been seized from us. During our tenure, 9 months,
Mm.
and earlier
Mm.
than us also.
Okay.
Now, Lordship, in connection with the earlier Russian,
Russian issue.
yes,
Mm.
another letter was written by the Assistant Director of Food Civil Supplies,
Mm.
Annexure I. There is clarification against nomination of volunteer for distribution of so and so in respect of Kohima Council, Village Council. With reference to the above cited subject and by number so and so dated 6 September 2022, I have the honor to state that the application received from the Tenime Welfare Union dated so and so for nomination of volunteer for distribution of food grains for so and so during the period of internal crisis of the Kohima Village Council. In this regard, this undersigned in the interest and for the welfare of the beneficiaries made temporary arrangement for distribution of food as per requested, so that the beneficiaries will not be deprived of their monthly entitlement of ration. Therefore, this arrangement can be nullified and the village council can take over the responsibility of their FPS once the issue is resolved and brought to the notice of this office. Now, in spite of the fact that the EAC has taken over as the caretaker on 26 July,
Mm.
the Food and Civil Supply Department has issued a letter on 13 September
Mm.
that these volunteers will take over on the distribution of rice, the rations meant for the village. So these are all under challenge, Lordship.
Mm.
Now, Lordship, this is to the communication to the EAC regarding the volunteers, nomination of volunteers. This is a letter dated 7 October 2022.
Mm.
Subject: nomination of distribution of PHH and PMJKY rice for Tolosuma Village FPS regarding. Subject: it's on the subject cited above, I'm stated as per Deputy Commissioner Chungdima order number so and so dated 31/5/2022, the impugn suspending the village council. It is stated that the EAC will take charge and control over the village council of Tolosuma Village till the issues resolved. Based on the directive of the Deputy Commissioner order, you are requested to make necessary arrangement in nominating someone for lifting and distribution. Now again, they are reiterating their statement.
Mm.
Now, Lordship, Annexure K, page 40, subsequently on 19 November 2020, an order has been issued by the EAC.
Mm.
We have approached the administration
Mm.
verbally
Mm.
that the way the organization they are functioning, in handling the village council administration. So a registration order was issued ultimately by the ESC. This order dated 19 November 2022, whereas it has come to the notice of the office that certain members of the tourism village are functioning as self-styled convener, secretary, office bearer of the Interim Village Management Committee, see Lordship. Whereas these individuals have not been authorized by the government or they are undersigned to function and exercise power in managing the affairs of the village, nor has permission been sought from the undersigned for such activities. And whereas the undersigned being the convener, concerned area administrative officer, as well as the caretaker during the suspension of the Tourism Village Council, it is unfortunate that this office has been bypassed and kept in dark by these individuals. And whereas such action of this self-styled individual are likely to disturb the peaceful yet fragile atmosphere in the village, which has been made possible due to cooperation and broad-mindedness of the right-thinking villagers of Toluzuma. Therefore, the aforementioned individuals functioning as self-styled office bearer of the said committee are hereby directed to immediately cease and desist from further acting in such unauthorized capacities, failing which the undersigned will be forced to take action in the interest of the public in general and Toluzuma village in particular. So, as restriction was issued. Now, Lordship may kindly appreciate the village council was suspended on 31/5/2022. Only in the month of December.
Suspended on, what was that date?
31/5/2022.
2020.
There is annexure D
Yes.
and FD. A committee was constituted to inquire into the allegation made. Yes, the complaint of the organization. Annexure L. This is important, Lordship. Lordship may kindly take note of the date. This is 20 December 2022. Lordship, I will be allowed to read because this is very important for us. Notification.
Sure, L. Is
Notification dated 20 December 2022. In continuation of this office, or even order dated number so dated 31/5/2022, an inquiry committee, Lordship, the suspension order they are referring to. An inquiry committee is hereby constituted with the following members. 1. Additional Deputy Commissioner Chungkidima, Chairman, ESC, Member, SDO Power, Chungkidima, Member, Project Director, DRDA, Chungkidima, Member, District Education Officer, CDPO, SDO, PHE Department. Now the roles and function of the committee, what they're supposed to do. Lordship, this is very important for us. An inquiry committee shall be an inquiry committee shall investigate and review the matter pertaining the following issues. 1. Power bills, arrears, Lordship. Mechanism arrears. This is important, Lordship. Why I'm saying this is important is I served for only 9 months. So area is beyond our appointment before. Areas and why the bill collected from the consumer has not been submitted to the concerned department, whether the village council, VEMB, this village education management board, has followed due procedure in this regard. Village electricity management board, VEMB is first. 2. The role of the village council and GB in issuance of NOC village pata with effect to the allegation on misuse of public property within the village.
issues of NOC village pata.
Yes, NOC.
Where do the village?
C. Whether the village authorities have adhered to the VDB model rules of 1980, whether the GPs have performed the duties expected of them till date. So this is the allegation.
Okay.
So basically the allegation is regard to power.
Power bills and then an issuance of NOC village pata.
Yes, yes. Now, Lordship, I kindly come to
Inquiry report.
yes. Inquiry was constituted on 20 December 2022. The time taken by a committee. They submitted the report on 11 September 2023.
Mm.
10 months. Submission of inquiry report of Tulusuma Village Council and subsidiary functionation. Now, Lordship, whether this inquiry was done giving us an opportunity to explain on the principle of natural justice, Lordship. It's an allegation against us. We will never, we will never call. Lordship, the report. So from 20 December 2022, September, more than 10 months, they did an inquiry and came out with 5 findings. It took them 10 months to do 5 findings. Very interestingly, Lordship. 44 in Annexure M, Lordship, is the letter. The page 45 is the report. 1. Whereas Tolosma Village Council and its subsidiary bodies such as Village Development Board Management Committee has been suspended by Deputy Commissioner Order number so dated 31/5/2022, and the administrative officer of the circle, EAC Stigma, has been given charge as caretaker of the village as per report submitted by EAC. It is observed, Lordship, no documentary evidence. It is observed that the Village Council was not constituted as per the norms of the Village Council Act. When I've been duly approved, chairman has been approved by and appointed by the government. The additional deputy commissioner, who is a highly qualified administrative officer dealing with the affairs of the village, is saying that we were not constituted under the, as per the provision of the Village Council Act. As per the, was not constituted as per the norms of the Village Council Act of 1978, Section 4. So, Lordship, that's why I was referring to Section 4. So, how the report has come?
Then what are the other?
The Village Council and the GBs failed to maintain law and order within the village. Where was the instance that we have failed? The GBs failed to report disturbance of public peace in the village to the concerned area administrative officer, which are expected from the council members and GBs as per the rules of the administration of justice and police in Nagaland and the Sanitary. Report of such the dereliction of DT be seen at EAC Chumila report serial number 6 ABC, which we don't have with us. Never given to us. So I'm saying I have not been heard. It was all the observation.
It is not in next in the report.
No, it is not here in the report. The report was given to us. It's not here. 3. It is also reported that since the recognition of the village by the government, no general public meeting of the village was conducted to discuss the welfare of the village. There is no document report of the village council members general meeting as envisaged in the Village Council Act, Section 10 and 11. Conduct of business. The village councils meet once in every 3 months, provided the chairman may summon the meeting of the council at any time if this is paid by 1/3 of the members. We have been appointed and we have served just for 9 months. And during that 9 months or so, Lordship, this frontal organization, I've made a specific allegation. They have been threatening from house to every village council members, the GBs, they were threatening. They were not allowing us to function. We were ready to testify, but no opportunity was given to us first. 4. In spite of the repeated manner from the concerned department official, the VDP member failed to maintain necessary records of activities pertaining to work, bookkeeping, and record of various schemes and programs implemented which are compulsory mandate as per the Village Development Board Rule 1980. Since the council and the VDP failed to perform as per the government guideline and procedure. No specific allegation. 5. The village council has accumulated an arrear, Lordship, why I was saying the arrear of the bill, of rupees 1,09,51,648 only against electricity bill as submitted by the power department. It is reported that the monthly fees were collected from individual household, but the bills collected were never submitted to the department, which is serious lapse of the village council and functionaries. Number 6, the village council. The village land patas are issued to multiple individuals without proper verification by the village council and GBs, leading to multiple duplicate patas, and multiple claims of ownership. The first Angamodi Center and under Social Welfare Department sanctioned during 2009 and approved by the government for construction in 2011 in the land donated by the village council was found to be encroached and dismantled as submitted by the department. The land allotted to the government primary school was also encroached. Lordship, may I see the year 2009? Was I there as a village council member, Lordship? I was elected only in 2021. They are bringing the previous allegations and dissolving my village council because of the misdeed of those members way back in 2009, 10, 11. Even the area. Lordship, can there be a light bill of 1 crore plus in a matter of 9 months for a village? It's all commoditized, Lordship, in village. They pay a nominal light bill per household.
No, this 2009, 2011, they're only saying that it was sanctioned in 2009
Yes.
and constructed in 2011.
Yes. So, but 11 also I was not there.
No.
And this man.
That has been found to be dismantled,
Yes.
encroached. and
Encroached, yes. But why is it us? The present village council members have dismantled, if that allegation is there. There's no specific allegation against us. That's what I'm trying to portray my case, Lordship. It is to submit that the village council, GB's VDP MC and subsidiary function under the village council seems to be badly informed or careless with the implementation of the government rules, regulation and act. In spite of numerous allegations and complaints in village, the village council GBs who are expected to watch dog of the government in the village and report to the authorities against such complaint remain silent, taking no proactive step to safeguard the government institution like government primary school, encroachment, dismantling of Angamodi Center, Lordship, pending electricity bill, etc. Moreover, there is no systematic satisfactory data records maintained for departmental activities undertaken in the village. In view of the above observation and taking into consideration the appropriateness of the time, it may be suggested that a new village council may be constituted strictly following the norms and guidelines laid in the Village Council Act, whereby those members who have failed to perform the duties, activities in the previous tenure as a village council, Lordship. Can you see this? In the previous tenure. They're not talking about our tenure. May be constrained to be members of the new proposed council or PDB members. Now, this report was submitted to the Deputy Commissioner, Kohima, on 11 September 2023. It took more than one year, 2 months for the Deputy Commissioner to forward it to the government. Annexure N, Lordship. So all the while, the intention is not to let us function.
So during that time, the EAC was taking care.
Yes. And no development activities were going on. The village were doing all cushy in the village. Now, this is in 19 November 2024. After a gap of more than 1 year, 2 months, the Deputy Commissioner has submitted the report to the Commissioner Nagaland, submission of inquiry report of Tulusuma Village Council and subsidiary functionaries. Now, Lordship. As I've already stated earlier, in the earlier repetition, this court has put up a query before the government. Whether under the Village Council Act, the Deputy Commissioner has the power to suspend. So, Lordship, may I come to Annexure P, page 49. This is the specific query made. WPC number to Mr. So-and-so, Government Advocate, come so-and-so, Gauhati High Court, Government Bench, reference WPC number so-and-so, reply to the order dated 9/12/2024, passed by the Honorable Gauhati High Court, Kohima Bench. So this is the reply given. So in inviting a reference to the above mentioned subject, I have the honor to reply the following on the query directed by the government, Honorable High Court. You are requested to bring to the knowledge of the Honorable High Court as and when the matter is listed again for further orders. 1. The first query. whether there is any power provided under the Nagaland Village Council Act 1978 as amended to the as amended to the state government to delegate its power to the deputy commissioner. No. They have admitted. Deputy commissioner has no role, has no power. Two, if so, whether such power has been delegated to the deputy commissioner? No. Three, whether the deputy commissioner can suspend a village council when the power to approve and dissolve a village council is exclusively within the domain of the state government. Now the reply, very cunningly they have replied first. The village council of Tolosuma along with the subsidiary bodies was only temporarily suspended by Office of so to ensure free and fair inquiry into the matter. They have not replied. They have not replied to the query. Thereafter, on 10 January 2025, immediately.
Next year, Q, huh?
Yes. Q, they have dissolved the village council.
So now the state government has dissolved.
And Lordship, the reason given, they have never stated basing on the inquiry. Because we have failed to function as village council members in accordance with the provision of the Act. The language law.
So now you're challenging this also?
Yes, we are challenging.
What's the- Okay, we'll resume at 2.
Court master, sir, court has, is there lunch going on right now? Or 2 p.m.? Thank you, court master, sir.
Gitu? Ah. Hmm. Budila tu. Allah sa ami aina movie interview ba tu. Tayo decide ko na ba. I didn't think that. Or please, I think that even the sheep. You can look at the wall. Not that. 1 hour. I mean, will you please do it? Something too much. There is constant access. Ini number yang cuma itu asal ada berapa? Ini number berapa? Itu berarti apa? Because the court will be confused, nah. Nah, so the green number. Oh yeah, that especially the resolving the council of that. Yeah. Hey, what? I don't know. Because you can kurang masuk. Itu prinsip legal itu, green number. Kami kita tadi, kita langsung mau jalan cuma. Kita patient ni lah, Albert. Kita patient. My only case is, though impugned order has been issued, inquiry done without hearing. Matene ba? Here were no. There will be papers coming on the video. We don't know what they will be asking. Now,
It's, where were we?
the impute order,
Ah.
the dissolution. No, Lordship, the principal act, no, this is renumbered again. So the dissolution part, dissolving the village council as per the all act that has been renumbered. Lordship, the paper, yes, it's under 31. So Lordship, I kindly come to the last page. Lordship. Number 10, renumbering of section 51 to section 54 of the principal act. Section 51, 52, 53, and 54 of the principal act shall be renumbered as section 28, 29, 30, and 31. So Lordship, may kindly come to annexure Q, page 50. Now, this is the order dissolving the village council. In exercise of the power conferred under section 31, one of the Nagaland Village Council Act. So now it's 31. As per the principal act, it's 51.
Earlier, yes.
Yes, yes.
51.
No, not 54. Earlier it was 54. So,
Dissolution, yes.
yes, if the Lordship, may kindly come to the section 54. Dissolution, Lordship, page 76. Now this will be renumbered as
31.
31, yes. If the government, on receipt of a report from the deputy commissioner of the district or otherwise, is satisfied with the situation that has arisen in which village council cannot function in accordance with the provision of this act, the state government may, by order published in the Gazette, direct the village council shall be dissolved from such date and from such period as may be specified in the notification. When the village council is dissolved under the provision of subsection 1, all members, notwithstanding that their tenure of office has not expired, shall from the date of dissolution vacate the office as such member. Now this has come into force, Lordship. Now we are already
out
of the village council, Lordship. Yes. Now, Lordship, just to sum up the whole issue.
No, just see where, just show us the provision where the village council can be dissolved and how the procedure to
No, there's no, just on the report. 54 says, Lordship.
There's nothing now about
nothing
the
beyond.
procedure.
So the report, now precisely.
It's a receipt of a report.
Yes, precisely it's the report now.
Yes, yes.
Now the report has to be
in accordance with law, and it has to be in accordance with law.
In accordance with law. So, and due opportunity, Lordship. Now the question of a due opportunity, why I'm saying this is because we were called. But whenever we went, we were made to sign in blank papers. So being village council members, just to sign in a blank paper, Lordship. So that whether we should sign or not, Lordship. Because there has to be a report. We should be summoned, Lordship. Our statement should be recorded. Now going by the report. Report. Now, Lordship, how a report has to be submitted, Lordship. It should be based on the statement of the complainant, the statement of against whom the allegation has been made, Lordship, as a matter of procedure, Lordship. Though there's no such prescribed norms under the Act, but normally a report is submitted basing on the statement of all the parties, of all the stakeholders. Now, this report at at page 45, I'm repeating the Lordship, but sorry for my repetition, Lordship. But this report, does not specifically says that we, the village council members, we involved in all those illegal activities, not reporting to the administration. It does not specifically say us. And they are referring to cases where we were not even village council members of the tenure.
Statements were not recorded.
Not recorded of either the complainant nor the village council, the petitioners who have been alleged to have involved in misconducts. No statement has been recorded. No, one very specific point, Lordship, which I would like to Lordship apologize. In a tenure of 9 months, whether I can have a liability of 1 crore light bill, my tenure from August 2021 to May 2022. Because clause 5 of the report is very
1 crore 9 lakhs.
Yes, 1 crore 9 lakh 51,000. Lordship, 1 crore is 100 lakhs. See the allegation that has been made against me as per the report. I have not deposited this money.
On that other, on one ground you were taking that report of the EAC was not given to you along with the report.
Yes. It was only after the village council was dissolved, we came to know of this report. And the time taken, Lordship has already taken note of that fact. But the report was, the inquiry was conducted on September 2023, Lordship. Whereas the inquiry was constituted on December 2022.
And who was the complainant?
The complainant, the frontal organizations.
Yes.
It took them 10 months to do the inquiry. And then the inquiry report was submitted to the Deputy Commissioner. Deputy Commissioner took another 1 year, 2 months to submit to the Commissioner. So the whole intention of the state respondent
1 year,
2 months
2 months
is just to debar us from functioning. And now, Lordship, we are in 2025, July. My tenure expires on March 2026.
Only a few months left.
Only a few months. But at least for us, such a big allegation has been made. So they have to give a report that, yes, specifically this, in this tenure, this village council member has done this, that, that. The allegation has to be specific, Lordship. I cannot make a blunt allegation tomorrow, saying that like, without knowing that, no, so-and-so person has embezzled 1 crore. No documentation, Lordship, the report. So for your Lordship, related reference, Lordship, the impugn order that I have challenged, I would like to point out, Lordship. Page 31, Annexure D, there's the first suspension order. This is the first impugn order, Lordship.
Yes.
Then the second impugn order, Lordship, will find at page 37, Annexure H, whereby all the village council records have been seized. Page 37, Lordship. Then Annexure L,
First is page 31,
Page 31,
then page 37,
37,
then next year L is
page 42, the committee constituted.
page 42.
Because it has functioned in a very biased manner. That's why we are challenging even the constitution of the inquiry committee. Then Lordship will kindly come to page 44, annexure M. This is the submission of the inquiry report by the ADC to the Deputy Commissioner. Then page 47, annexure N. Submission of the report. And this report was submitted during the pendency of the early repetition motion. They realized that they have not submitted the report to the government. And annexure Q. The last impugn. Dissolving the village council. So my humble submission is to the Lordship. The whole process of suspending and dissolving the village council was at the behest of some unauthorized organization. Without facts and figures, Lordship, I've already pointed out the complaint. The complaint is also not specific. No specific allegation has been made.
Let's see the complaint again.
The
Page,
complaint
page.
is. The complaint is at page 29. 29, annexure C. The content, Lordship. Number one. They have taken four-point resolution, Lordship. To immediately accept and notify the resignation of Sri Nitsesovena, head GB, and Sri Nipete There, Chairman Village Council, who tendered their resignation on 21/3/2022.
You had resigned.
One of the petitioner from the chairmanship, not VCM, okay, Lordship. Lordship, may kindly take note of that. Because VCM is one election under section 4. The election of chairman is under section 7. I have resigned as a chairman, but not as a VCM. That is one complaint. Second is to immediately nominate a committee to take stock of the village administration.
No, but here, what is the allegation?
Nothing. How they have acted just basing on this complaint.
Okay, government.
My pleasure.
Yes. Yes.
Left is a Lordship.
Hmm.
Lordship. The state respondent has filed affidavit in opposition on 21st July 2025, Lordship.
Yes.
Lordship, in fact, this is the third round of litigation, Lordship.
Third round.
Third round. Lordship,
They are confused because one petition was filed by the GBs. So GBs are not elected village council members.
Lordship.
They form part and parcel of the village council, but they are not elected as.
Okay.
So that should not confuse the court with that.
Lordship, in fact.
And in fact, here, Lordship, if I may, the village council, the GB, the court has allowed them to function as GB.
They're functioning.
The
They are
government is
functioning
not
as-
allowing them. Government is not allowing them. We'll be approaching the court very soon, Lordship.
Yes.
Lordship, that we have stated in our affidavit in opposition that more particularly paragraph 5. Para 5, Lordship,
Five.
of our affidavit in opposition. Lordship, there was a multiple complaint received from the frontal organizations. Five frontal organizations. That is Tolozuma Student Union, Tolozuma Youth Organization, and Tolozuma Women Organization, Welfare Group, and Tenemia Welfare Union. And have passed a resolution on 21st/5/2022 at the Government Primary School, Tolozuma, Lordship. 4.4 resolution was met. which I have annexed in our affidavit.
Yes, we have already seen those four.
For resolution, they have resolved 4.5,
Mm,
which is at page 9, Lordship.
mm,
Annexure A.
mm.
Annexure
No,
A.
what I'm saying is,
Lordship.
resolution doesn't say anything. There is no specific allegation.
Lordship,
Mm,
in fact, number 1,
mm,
to immediately accept and notify the resignation of Sri Nitozo Venu, head GP, and Sri Nepete Tere, Chairman Village Council, who tendered their resignation on 21st/3/2022 on moral ground. In fact, they have tendered their resignation on moral ground.
mm,
After the complaint, after the resolution was passed, they have tendered their resignation, Lodge. So they have the 4.1 is to accept the resignation, Lordship.
mm.
And here the chairman, he is the petitioner number 1 in the instant petition, Lordship.
Mm.
Lordship, since there was a complaint received from the various organization, Lordship, and in order to take stock of the situation, there was a lot of hue and cry in the village, Lordship. So in order to take stock of the situation, law and order situation, Lordship, order was passed by the deputy commissioner. That is on 31st May 2022, Lordship, which will find in Annexure 11, Lordship. Lordship, if I may allow to go to the content of the order, Lordship, page 11, Lordship, Annexure B. If I may allow to read, Lordship. Order dated 31st May 2022. Whereas it has come to the notice of the office of the undersigned through multiple complaints and representation that the present village council of Tolosma is not able to function according to the norms of the Village Council Act 1978 and VDP Model Rules 1980, and the council and GBs have lost confidence of the public in general of Tolosma village. The same has been brought forth through recurrent complaint, public demonstrations, and protests. Very important, Lordship. The Tolosma Village Council, despite being a government mandate body, as alleged by various groups and public of Tolosma, has failed to exercise and function their authority within their village jurisdiction in effective execution of government directives and programs. Further, the Tolosma Village Council in the meeting held on 26 May 2022, very important, Lordship, held the meeting on 26 May 2022 at Deputy Commissioner's Office Chamber, reaffirmed their inability to exercise and function within their village jurisdiction and agreed to abide by the mandate of the citizens of Tolosma village, and such allegations are not only serious but warrant a detailed inquiry on the matter. The Tolosma Village Council has been alleged to have failed in the duties as mandated under Section 12(2), which says that to help various government agencies and carry out development works in the village. 2. Section 15(1). The village council shall be auxiliary to the administration and shall have full power to deal with internal administration of the village. 3. Section 15(2). To enforce orders passed by competent authority on the village as a whole. 4. Section 22. The deputy commissioner and subordinate officers shall have control over the village within their jurisdiction. Since the allegation made against the council are very serious in nature, therefore, in view of the aforementioned reason, it shall be prudent to thoroughly investigate the allegation made against the VCM and the GBs. An investigation and review committee shall be constituted shortly for free and fair investigation of the allegations made against the council, the Tolosma Village Council, and its subsidiary bodies such as the Village Development Board Management, VDBMC, stand temporarily suspended till further orders. in accordance with Section 22 of the Village Council Act 1978. Further, in the interest of public service, the ESC City Kohima will take charge and control over the Village Council of Tolozuma Village till the issue is resolved, Lordship. Lordship, from the content, from the order dated 31st May 2022, Lordship. Lordship, it has been clearly mentioned there was a meeting that was held on 26 May 2022, Lordship, in the office chamber, in the Deputy Commissioner's office, Lordship. And even the village, even the VCMs, even the petitioners and all, they have reaffirmed their inability, Lordship. Lordship, that has been clearly mentioned in the order, Lordship. And moreover, Lordship, it is not a dissolution order, Lordship. It's a temporary, Lordship may kindly appreciate that in the order it stated that temporarily suspended till further orders, Lordship. Lordship may kindly come to the section 22. Section 22 of the Village Council Act, Lordship. 1978, Lordship. Section 22. Page 67. Control of the village, Lordship. Subject to the general superintendence of the state government, the deputy commissioner, additional deputy commissioner in charge of the subdivision ESC or circular officer shall have control over all the village councils within its jurisdiction, Lordship. Under Section 22, Lordship, that the deputy commissioner as well as the ADC shall have control over the village council within its jurisdiction, Lordship. Lordship, in order to take stock of the situation, Lordship, they were temporarily suspended, Lordship. It's not a dissolution, Lordship, but it's a temporary suspension, Lordship. Thereafter, Lordship, after it was temporarily suspended, Lordship.
Inquiry committee was.
Lordship, inquiry committee was set up, Lordship, which they are challenging, Lordship, which the petitioners.
But why after so long? The suspension was 31st May and inquiry committee is constituted only on 20th December.
Lordship, that I have stated in my paragraph 6 of our affidavit, Lordship. Paragraph 6, Lordship. Lordship may kindly come to the relevant paragraphs. If I may continue to from paragraph, if I'm allowed to read the paragraph 6.
Paragraph 6.
Paragraph. Lordship, that with regard to the statement made in paragraph 20 and 21 of the writ petition, the deponent at the cause of petition respectfully begs to state that since the allegation made against the petitioners are very serious in nature, the notification for inquiry committee was immediately notified. However, the matter is put on hold for the fact that the matter is subsidies before the Honorable High Court. It is pertinent to state herein that on the receipt of the High Court order dated 22/2/2024, the state respondents have acted upon inquiry report prepared in accordance to law, which was submitted by the additional deputy commissioner on 11 September 2023. Thereafter, the deponent by letter, that is deponent by letter number so and so, dated 19/11/2024, had submitted the inquiry report of Tolozuma Village Council and subsidiary functions to the Commissioner Nagaland for approval of the inquiry report. The deponent also respectfully begs to state that the state respondents are serious in resolving the issue. However, due to the model code of conduct for Lok Sabha election, which was enforced, the district administration office could not expedite the matter as where was occupied with Lok Sabha election. It is, however, to state herein that an order so and so that was passed, Lordship. Because of this model code of conduct, Lordship, of this Lok Sabha election, Lordship, but the administration, the respondent could not expedite the matter, Lordship. However, Lordship, Lordship, the additional Deputy Commissioner, Lordship, has submitted an inquiry report, Lordship. Inquiry report of Tolosma Village Council and subsidiaries on 11 September 2023, Lordship. And thereafter, Lordship, the Deputy Commissioner has forwarded the inquiry report to the Commissioner, Lordship, which is at page 26, Lordship. Page 26, Lordship. And the report is in page 27, Lordship.
Did you record the statements of the petitioners before passing this report?
Lordship, in fact,
Because principles of natural justice demands that at least whenever an inquiry is conducted,
Lordship.
you know very well
Lordship.
that statements are always recorded. Then only after that, the inquiry report is prepared. So was it done in accordance with the principles of natural justice? And what about this report of the EAC City Kima? It says report serial number 6 such and such, but it is not enclosed along with the report.
Lordship.
That also should be made known to the
Lordship.
petitioners, yes. So that they can also answer to it. What kind of a report?
Lordship.
You conduct a fresh inquiry. I think this is not a proper inquiry.
Lordship.
We will give a direction for a fresh inquiry.
Lordship, but till the time the dissolution.
No, that dissolution will quash, but the suspension will be in force.
Lordship, but under,
Suspension, because suspension, that will not be counted as, yes,
if I may be allowed to
yes.
explain to this, section 22.
Because
subject-
when there are complaints against you,
Yes.
Lordship.
just as a government servant, when he is under disciplinary proceedings, they are suspended.
Lordship.
So that the disciplinary
So-
inquiry, so also it will be suspended and then the inquiry will be reconducted.
Lordship,
Lordship.
in this matter,
Yes.
only the government can appoint,
No,
approve.
yes.
For suspension, so the government should.
No,
Not the deputy
suspension is temporary. So
It's a temporary.
where does it say suspension that it will, that also will be
Because
done?
there's
by
no
the government?
provision for suspension under the act.
No, but this is only for superintendents. It comes
Lordship.
under the superintendents.
Lordship has rightly pointed out.
Ah.
Section 22, Lordship.
Yes, section 22,
So, but
superintendents,
it-
just
for
to
that-
conduct the
yes,
inquiry.
Lordship.
Agree
Yes.
to Lordship, what-
Yes.
yes, superintendents of the village council by the administration, I'm not denying that fact.
Mm.
But that order should come from the government level, Lordship. The government should issue that order, because Lordship has, I already pointed out in that court order.
Mm.
Lordship may kindly come to the query of the court. If I may just make a submission on this. Page 49, Lordship.
Page 49.
Lordship, yes, kindly, if Lordship you can kindly.
Mm.
Number 3, query number 3, Lordship. Whether the deputy commissioner can suspend a village council when the power to approve and dissolve a village council is exclusively within the domain of the state government, Lordship. That is,
Yes, agreed. Approval, dissolution, everything is with the state government.
Lordship.
but suspension, Lordship, this does not speak about suspension. This speak about superintendence.
So superintendents means they can control all the functionings,
Yes.
all the functionings of the village council.
Yes.
And
Yes.
other vested interests like you said, frontal organizations taking charge of the ration and all that, that is absolutely wrong. I mean, that is illegal.
Yes.
But now it's the EAC who is in
Yes.
charge.
Lordship.
So,
Control.
Lordship,
Yes,
if that be the case, Lordship.
yes.
So if court can pass a specific direction to that effect, because since the act provides that the administration will take stock of the situation, what we have, I've been informed by the petitioners, the frontal organization are,
No, they cannot. They cannot.
so some restriction may be issued, Lordship.
They cannot do
Yes.
that.
Lordship, as per the order, Lordship, ESC City Kima, Lordship.
Yes, that order is already there.
Caretaker.
Yes.
Yes.
So in fact, Lordship,
That should not.
what stopped the ADC or EAC to conduct the inquiry? Because there was no stay order. They're saying subjudice. The matter was subjudiced, but there was no stay order. So there is a very. it's a
Actually,
very-
they could have gone ahead, actually.
Yes.
Uh-huh.
And now they're taking the lineage of the model code of conduct.
Lordship,
We're
in
waiting
fact-
for the local, model code of conduct all this while.
In fact, when this order was passed, Lordship, they approached this honorable court, Lordship.
Mm.
But
No,
we were
Lordship,
having a writ
that
petition.
was, Lordship,
And
I,
that matter
if,
was subsidized before the honorable.
Lordship, if I may be allowed to clarify.
Mm.
My learned friend has, thank you, my learned friend has already annexed the order, page 14 of the government affidavit, Lordship.
Yes.
This is to do with the Gamburas. The Gamburas also challenged the 31st May 2000.
No, we will not go into
Yes,
that.
Lordship, for your, because my learned friend was saying this is a third round of litigation.
Lordship, in
This-
fact, there was Gambaras as well as the village council members.
So,
Lordship, may kindly come to my affidavit, to the, page 18, Lordship, para 7, Lordship. Page 18.
Your
para 7,
affidavit.
On, Lordship. Page 18. This is the order passed by this honorable court.
Oh, cha. Page 8.
Page 18, para 7,
Okay.
Lordship.
Yes.
The record further reveals that there is an affidavit in opposition filed by the respondent number 7 to 11, wherein it has been mentioned that the petitioner number 1, 4, and 7 were appointed as Gambaras on so and so after the Tolozuma village was officially recognized by the state government. The petitioner number 1 had submitted his resignation on so and so on moral grounds. The petitioner number 7 had also submitted his resignation on so and so of his old age. Under such circumstances, the respondent number 1 and 7 had no locus standi to pursue the present proceeding. It has been mentioned in the said affidavit that in opposition that the petitioner number 6 and 7 were appointed on Gambaras in the year 2017
That's
and
the
15.
observation.
Lordship, there are some Gambaras as well as some PCMs, Lordship.
Lordship, may
In
kindly
the-
come
in
to
the-
their
in the
affidavit
earlier-
at page 4. They have quoted page 4, Lordship. They have quoted the court order. Second paragraph.
No,
The
but
quote.
in the course title, in WPC 336,
Lordship.
all are Gambura.
All are Gamburas.
Gambaras as
So
well as
nothing to do with the, so the court has observed that since the 31st May 2022 order does not speak of Gambura, Lordship. Lordship, may kindly see the page 4, under court, page 4 of the affidavit of the state. Under court. Consequent this court, Lordship,
Consequent.
this court finds no reason for interference with the impugn order because the order does not affect us, the GPs, the 315, the suspension order, as well as the communication. Be that as it may, this court, however, observed that the petitioners, except petitioner number 1, who has already resigned and accepted, 3 died, 7 died, Lordship. Continues to be Gambura. The others continue Gambura of the village, wherein they have been duly appointed till they discharge terminated in accordance with law. So by this order, we have been allowed to function as GB, but they are not allowing us.
No, but here in this petition, we will not go into that.
Yes, we have nothing. So they should not mix up this petition, Lordship, what I'm trying to say. Because that is Gamburas.
Okay.
That should not be mixed up.
Is that agreeable with you? Yes.
Lord.
Okay.
Heard learned counsel for the petitioner, Mr. N. Muzui, and learned government advocate V. Momi for the state respondents. Stop. In this petition, under Article 226 of the Constitution of India, the petitioners are challenging the dissolution of the Tolozama Village Council by the impugn order number such and such, you check from the prayer portion, okay, dated 10/1/2025. Stop. The petitioners have also challenged the impugn order dated 31/5/2022, temporarily suspending the village council and its subsidiary bodies of the Tolozama village. The petitioners have also prayed for a direction to quash and set aside the impugn order number such and such dated 26/7/2022, directing the petitioners to hand over all the records of the village, the impugn notification bearing number such and such dated 20/12/2022, the impugned letter number such and such dated 11/9/2023, comma, impugned letter number such and such dated 19/11/2024, and
11/9
that's
and
what the-
19/11 are the inquiry report
yes,
submission.
yes, that's stop. Para. It is the case of the petitioners. How many petitioners here?
Lordship, they are,
All the members, all the.
no, 8 of them. 8 of them are here.
It is the case of the petitioners that the village council of the Tolozama village was legally set up in terms of the provisions of the Village Council Act of 2009. And the government had accordingly accorded its approval by issuing a circular dated 15/4/2021. No, sorry.
Village,
Last line. Oh, don't say that. The government had issued a circular for selection/election of a new team of village council, and the respondent number 5 by circular dated 15/4/2021 had, what was 15/4/2021?
to constitute the village council.
15/4/2021 had directed the villages under Chumukudima Circle to submit the list of newly elected/selected village council members on or before 26/4/2021. Stop. Thereafter, the
Head GB.
head GB had forwarded the names of the new village council members to the extra assistant commissioner, Chumukutima, Dimapur, Nagaland, along with the meeting minutes. So, in pursuance to such list and letter from the ESC Chumukudima, the deputy commissioner.
No, the government has approved the list.
Where is that?
Lordship, I've just annexed the list only, 26, page 26. Under serial number 29. This list was approved by the,
And the said list was approved by the government
in terms of the act, Lordship.
in terms of the Village
Act.
Council Act.
Yes, Lordship.
Stop. Then what is this Annexure B?
This is
Okay.
Chairman.
Thereafter, the Deputy Commissioner Dimapur issued the order dated 19th August 2021,
Yes.
approving the name of, this is petitioner number?
No one.
Petitioner number 1.
Petitioner number 1
13.
as the Village Council Chairman
Yes.
of Tolozama Village Council. Stop. When the petitioners were functioning as village council members, you can sit, it's okay.
Yes.
Were functioning as village council members, a complaint was submitted by some organizations of the village, organizations of the Tolozama village, namely Teneme Welfare Union, Tolozama Women Organization, Tolozama Youth Organization, Tolozama Welfare Group, and Tolozama Students Union. Stop. Complaint to the Deputy Commissioner. complaint to the Deputy Commissioner Chumukadima was submitted by such and such. Okay. Stop. On receipt of such complaint, comma, the Deputy Commissioner Chumukadima issued the impugn order dated 31st May 2022, temporarily suspending the village council and its subsidiary bodies. Stop. Thereafter, by the order dated 26 July, you are impugning this also, na? By the impugn order dated 26 July 2022, the Extra Assistant Commissioner
Yes.
Sidikima
Yes. Caretaker.
yes, was appointed as caretaker of the village till further orders, and it was directed that all registers, records, cash books relating to the village council and its subsidiary bodies should be submitted at the office of the EAC Sidikima on or before 28th of July 2022. Stop. Para. Subsequently, an inquiry committee was constituted by impugn notification dated 20th December 2022 to look into the allegations against the village council / petitioners, village council members / petitioners. Stop. The inquiry was conducted and the inquiry report was submitted to the Deputy Commissioner Chumukudima by the Additional Deputy Commissioner Chumukudima by letter dated 11 September 2023, and the same was forwarded to the Commissioner Nagaland by letter dated 19th November 2024. Basing on the inquiry report, the government of Nagaland by order dated 16th, 16 January 2025, in exercise of the powers conferred under section 31 under bracket 1, 31 clause 1 of the Nagaland Village and Tribal Councils Act 1978, dissolved the Tolozama Village Council under Chumukudima district. Stop. Being aggrieved, the petitioner is before this court. Stop. Para. The submission of the Learned Counsel for the petitioner is that
The resolution will be 10 January. It will be 10.
oh, this is not 16, nah? Just 10 January. 10 January 2025.
Yes.
Yes, yes. The submission of the Learned Counsel for the petitioner is that the allegations made against the petitioners is vague and there is no specific case of no, there's no specific allegation against them. Stop. It is also submitted that the inquiry was not conducted in accordance with law, inasmuch as the statements of the complainants nor the statements of the petitioners were recorded during the inquiry. Stop. The inquiry report also speaks of one report given by the ESC Sidikima, comma. However, such report was also not supplied to the petitioners. Stop. In other words, it is stated that the inquiry was conducted against the principles of natural justice. Stop. The petitioner has also pointed out various discrepancies in the inquiry report, stating that in the inquiry report, it is stated that the village council was not constituted as per the norms of the Village Council Act 1978, comma, whereas the village council was a duly approved council by the government, by the state government. So further in the inquiry report, it is also stated that the village council has accumulated an area bill of rupees 1,951,648 against electricity bills as submitted by the power department. Stop. It is the submission of the learned counsel for the petitioner that the village council, the petitioners had been functioning only for 9 months and could not have, no, only for 9 months, and therefore the area bills of such a huge amount could not have been accumulated during their tenure, and that the same has been carried over from the various from the previous village councils. Stop. Para. The learned counsel for the petitioner also submits that the deputy commissioner does not have the power to suspend the village council, and that it is only the state government which can issue such an order. Stop. Learned counsel for learned government advocate. Yes.
I forgot to point out.
Yes.
Lordship, if Lordship come to annexure O,
Mixture of.
what I'm trying to prove is that it does not include my tenure. Why, Lordship?
That electricity bill, na?
Yes, I want to show the date, Lordship. Oh, page 48.
Page
48 of the writ petitions.
yes.
Files and records of Tourism Village Council, that was seized, okay, Lordship, with effect from 2017 to 2022.
Where is that?
On top.
Page 48.
48.
Oh, 2017 to 22.
Yes, so I took over in 21.
You took over in 21.
And they were doing the report from 17.
No, that's why. In
Which
that part when I said electricity bills, na, that they could not have there, you just put in one line as the petitioners had taken over only from
2021.
No, no,
August,
the date.
August
Uh,
19.
only from August 2021. But as the petitioners had taken over as VCM only from August 2021. Whereas the inquiry report talks about records, files and records with effect from 2017 to 2022. Okay.
My apologies. because
Yes.
I forgot.
Yes. Parana, Learned Government Advocate Riji Momi has submitted that under Rule 22 of the Nagaland Village and Area Councils Act 1978, the Deputy Commissioner, the Additional Deputy Commissioner, and the EAC have general superintendents over all the village councils within their jurisdiction. And therefore, on receipt of the complaint against the petitioners, the Deputy Commissioner Dimapur, Deputy Commissioner Chumukutima had issued the impugned order dated 31/5/2022, temporarily suspending the village council and its subsidiary bodies till the issue was resolved and till the finalization of the inquiry. Stop. He has therefore submitted that the suspension of the village council cannot be equated with dissolution, and the same is within the powers of the Deputy Commissioner of the district. Stop. Next paragraph. Without going into the other aspects of the matter, this court is of the view that the inquiry was not conducted in accordance with law. Stop. This court is of the view that the petitioners were not heard and their statements were not recorded, and the allegations against them were not supplied to them so as to give them an opportunity to explain about the circumstances. Stop. Accordingly, this writ petition is disposed of with the following directions. Number one, the dissolution order, the impugned dissolution order dated 10th January 2025 is quashed and set aside. Now, all those orders in favor of the organizations, that is not material anymore.
Yes,
Because now EAC is there. Yeah.
So, Lordship, that's
Yeah.
strictly
Yes.
monitored.
So I will quash only this dissolution order. Then January 2025 is quashed and set aside. The impugned order dated 31st May 2022 issued by the Deputy Commissioner is not interfered with, as this court is of the view that the Deputy Commissioner has the power under Rule 22 of the Nagaland Village Council, Village and Area Council Act 1978 to pass such an order pending the inquiry. Stop number 3. The DC shall conduct a fresh inquiry after giving due opportunity to the complainants as well as the petitioners to present their case and to record their statements. Then next, this Deputy Commissioner Chumugutima shall ensure that the administration of the village council is conducted only by the district administration and not to allow any other non-governmental organizations to interfere in the functioning of the village administration. That will do.
Lordship, if the time bound may be given, because
Ah,
they are
yes,
taking
yes,
so
yes,
long.
yes.
They may go
Next para.
to 28,
The inquiry shall be conducted within a period of 1 month.
1 month.
Lordship, 2 months, Lordship, since
No, you have all the papers now.
Yes,
Just
they
to,
have, yeah, they just have
there
to.
is a lot of exercises to be done, Lordship.
okay, within 2 months, the inquiry shall be completed by the Deputy Commissioner Dimapur / respondent number. Four. Respondent number 4 within a period of 2 months from the date of receipt of this order.
Obliged, Lord.
For hearing item numbers 20 and 21.
My please, Your Lordship.
Yes.
The Lordship here, the petitioner is praying for granting minimum scale of pay SLS for payment of your salary, Your Lordship.
Minimum scale of pay.
Yes, Your Lordship, and as far as the minimum scale of pay is concerned, the petitioner case is covered by ON dated 5th March 2025, Your Lordship. May I place the ON?
Okay, then the other prayer is
Your Lordship, and with regard to salary, in the earlier occasion, the state government has stated that some document of the petitioner need to be rectified in order to pay the
rectified.
salary. Yes, Your Lordship. Therefore, I submitted the necessary documents to the state respondents on 14 May 2025, Your Lordship.
Till now, you're not getting your salary.
Yes, Your Lordship. Therefore, my humble prayer that a specific direction may be given to the respondent, particularly to the respondent number 2, Your Lordship.
What is the ground taken by the government?
Yes, Your Lordship, I.
Why they are not getting?
Yes, I have already filed my affidavit. Your Lordship, now the reason why the salary could not be released is because there is some error in the PIMS, Your Lordship. Now it has become a policy that everyone
PIMS,
has to be registered in the PIMS. Unless and until your name get registered in the PIMS, the salary cannot be dispersed. Now what happened is that there is some errors in the petitioner's particulars, Your Lordship. I have written in my affidavit in opposition paragraph 3, Your Lordship.
Paragraph 3. We could pay for this.
Date of birth does not match the PIMS and other, Your Lordship. The error that is occurring in the petitioner's particular.
Your paragraph?
Paragraph 3, Your Lordship. And the lower portion, Your Lordship.
1 minute.
Affidavit in opposition. Got it, Your Lordship. Page 2.
Opposition.
Page 2, paragraph 3.
Wait. This is an affidavit in opposition filed for on behalf of the state.
You got it, Your Lordship.
Page 2.
Page 2, paragraph 3.
No, here page 2, paragraph 3 is only in regard to the statement made in paragraph such and such, the answering deponent, like that.
No, I think that will be different again. I think there is 2, 3 affidavits here.
Oh, I think additional affidavit.
Yeah.
Additional affidavit.
1890.
One is filed on 26/25. One is filed on 19 September 2024.
It will be the latest one.
20 June 2025. So here, para 3,
Additional affidavit.
yes, additional
Yes,
affidavit.
Additional affidavit,
Ah.
para 2. Page 2, para 3.
Yes.
It's on the lower portion, Your Lordship.
Mm.
I have categorized like as to,
Employees with minor clerical errors, employees with multiple errors.
they have already, like the government has already categorized it. Category A.
Three
will be-
categories.
Yeah, with employees who doesn't have a discrepancies. Category R1 and R2 for minor clerical errors and multi errors. Now the petitioner number 1, Your Lordship, serial number 15. There's a date of birth.
Does
His
not
date of
match.
birth does not match with the PIMS as well as
PIMS
with
and
other.
other.
And petitioner number 2, serial number 46, name to be corrected in the PIMS. DOP does not match PIMS and other. Father's name, surname is missing in the PIMS. So these are the corrections that need to be done in the PIMS, Your Lordship. So what the department and the government is saying is unless and until it is corrected, the salary cannot be dispersed. So let it be corrected. And once it is corrected,
No,
Your
but
Lordship,
this
the
is
salary-
filed in 2022. 22, this petition, isn't it?
Yes, Your Lordship.
Until now, you cannot make these corrections.
Your Lordship, I think there is a procedure. Everything is going in a bulk, and Your Lordship, it is sent in a year to 28 August 2024, Your Lordship. So every record is going in the bulk, Your Lordship. So maybe.
Have you
because of
done the
that-
necessary
Yes, Your
corrections?
Lordship. Yes, Your Lordship. Accordingly, I have submitted to the department on 14 May 2025, Your Lordship.
14 May
2025.
2025. Recently, just 2
Yes,
months
Your
back.
Lordship.
So how much time will the government take
Lordship,
to rectify?
Let's 3 months be granted so that
No.
rectification can all be done, and as well as the department can according take step in releasing the.
Your Lordship, here, all the petitioners is on the verge of retirement, so a short time may be given. Your
When are
Lordship.
they retiring?
The petitioners number 1. The petitioners number 1 has been serving the department for more than 31 years, for more than 30 years, Your Lordship. And the petitioners number 2 has been serving the department for more than 29 years, Your Lordship.
Let's see. Third Learned Council for the.
Your Lordship, it's
Yes.
WPC number 177, 2023.
Oh, there are 2 petitions here. Yes.
Here, I have also received the forwarding letter from the executive engineer, PWD Mon Division, Your Lordship.
Your Lordship, we can go one by one. The matters are a little bit similar, but we can dispose it.
Okay, well, first, this is WPC 147. Learned Counsel for the petitioner, MS such and such, and Learned Government Advocate, Ms. Levika. Stop. Paragraph. The petitioners in the present writ petition are aggrieved by the non-payment of their salary with effect from March 2020 till date. And also for not granting them the minimum scale of pay. Stop. Learned Counsel for the petitioner submits that the petitioner number 1 was appointed on fixed pay of rupees 750 by an office order dated 2/9/1994, issued by the executive engineer, PWD Housing, within brackets, division number 1, Kohima, Nagaland. Stop. The petitioner number 1, having employee code number 0038, is serving the department as work charge semi-skilled labor on fixed pay continuously for more than 27 years.
30 years, Your Lordship.
No, in the petition, it says 27 years.
Yes, since the petition is filed in the year 2022, Your Lordship.
Continuously for more than 27 years, and presently she has completed 30 years of service and receiving an amount of rupees 3,200 per month. Stop. Para. The petitioner number 2 was appointed as Mali on fixed pay of rupees 750 per month by an order dated 21/6/1998. No, sorry. By an order dated 9/7/1998, issued by the Executive Engineer, PWD Housing, Division Number 1, Kohima, Nagaland. Stop. The petitioner number 2, having employee code number 0083, is serving the department as Mali on fixed pay continuously for more than 24 years
No,
and presently
27.
served more than 20 and presently serving for 28 years and receiving an amount of rupees 5,900 per month. Stop. Para. The petitioners had submitted various representations dated 18/5/2022 You had submitted only one representation, or
Your
after
Lordship, I
that?
submit, two representation, one representation.
Initial
The
20 and
petitioners
21.
had submitted representations dated 18/5/2022 to the Engineer-in-Chief, Nagaland PWD, Nagaland Kohima, praying for release of salary and also for granting scale of pay. Stop. However, the petitioners' representations were not considered. Stop. Being aggrieved, the petitioner is before this court. Stop. The state respondents represented by Ms. Vivika, government advocate, has submitted on the basis of the additional affidavit filed on behalf of the state respondents that there are thousands of work charge employees, both on scale pay and fixed pay. Stop. The government of Nagaland had carried out a verification drive of the work charge employees under the Nagaland PWD. Stop. During the verification process, several discrepancies in employee records, including name, father's name, date of birth, and ghost employees were detected. Stop. Based on the findings, the employees were categorized into 3 categories, isn't it?
Yes,
3 categories, Category A dash, employees with no discrepancies in their records and are regularly receiving their salaries. Category R1 dash, employees with minor clerical errors in their documents. And category R2 dash, employees with multiple errors in their documents. Stop. The Engineer-in-Chief, Nagaland PWD / respondent number 5, vide letter dated 28/8/2024, had written to the government for verification of work charge employees of the category R1 and R2 under the Executive Engineer PWD Housing Division dash. What is OM clearance?
Your Lordship, that is like as per the office memorandum.
Just say for clearance.
Yes.
For clearance. For clearance. Stop. the details of just say in respect of petitioner number 1, the date of birth did not match in PIMS and other. And in respect of petitioner number 2, the name had to be corrected in the PIMS, comma, the date of birth did not match in PIMS and other, and the father's surname was missing in the PIMS. Stop. Due to these discrepancies, the salaries of both the petitioners could not be released from 2020 onwards. Stop. Therefore, unless the discrepancies in the PIMS are rectified by the Department of PNAR, Government of Nagaland, and clearance is given, the salary of the petitioners cannot be released. Stop.
Paragraph up is relating to the prayer of minimum scale of pay. So as far as that is concerned, that will be covered by
the OM. Yes.
5th March.
Yes. Learned Government Advocate submits that as far as the petitioner's prayer for minimum scale of pay is concerned, the same is covered by the Office Memorandum number AR-3/GEN-67/2001 dated 5th March 2025, issued by the Government of Nagaland, PNAR Department. Stop. The petitioner's cases will be considered for conversion of fixed pay to scale pay in view of this Office Memorandum of 5th March 2025. Stop. Para. The court has considered the facts and circumstances of the present case and the submissions of the learned counsels for the parties. Stop. The learned counsel for the petitioner at this stage has submitted that all the discrepancies have been cleared and required documents have already been submitted to the Department of PNR, isn't it?
No, respondent number 6.
Oh.
So that is executive.
Oh, yes, yes. And have been submitted to the respondent number 6/executive engineer, Nagaland PWD, such and such, on 14th May 2025. Stop. Accordingly, the writ petition is disposed of with the direction to the state respondents to consider the cases of the petitioners for conversion of their wages to scale pay in view of the Office Memorandum dated 5th March 2025. Stop. In as far as the discrepancies in the PIMS is concerned, as the learned counsel for the petitioner has submitted that the required documents have already been submitted to the concerned department, the concerned department/executive engineer, PWD Housing, Division number 1, Kohima, Nagaland, the respondent number 6 shall submit the same to the Department of PNAR, respondent number 2/respondent number 2 expeditiously, and thereafter the respondent number 2 shall take steps for clearance of the petitioners.
Rectification, because
For rectification of their service records, so that they can receive their salaries. Stop. the entire exercise shall be completed within a period of, what were you saying?
2 months will be
2
granted.
months, within a period of 2 months from the date of receipt of this.
Your Lordship, my humble prayer that a full payment may be given after rectification of the
think that
documents
would be
that
No, no,
effective from-
as soon as it's cleared, everything will come, whatever you have not received, na, you will just.
From the date of receipt, Your Lordship.
Yeah, from the date of receipt of a copy of the sort. Then
In
177.
177, Your Lordship, I've also received a forwarding letter stating that the petitioner documents are tally in the PIMS and other, Your Lordship.
Forwarding on.
We are, Your Lordship, the petitioner are only praying for releasing of salary. They are not
Yes,
praying
ma'am.
for minimum of salary pay. They are only praying for releasing of their salaries.
Okay, then for this, there should be no problem. Have you
So,
given a
at
copy?
least the-
Uh,
Yeah,
Please give her a
Your
copy.
Lordship, a specific direction may be given
Yes.
to the respondent.
So
number
their case is already cleared.
so,
Uh.
no, it is, has been forwarded to the P and.
No, no, that's why, but there is no discrepancy now.
Yes.
Yes. See, all related documents are tallying and same with the PIMS. So now they are to be brought under that category A.
Oh, maybe, Your Lordship.
Yes.
Because now only I'm receiving this one.
Mm. So in
Your
that
Lordship,
case,
accordingly, I have submitted this letter to the engineer in chief on 2nd June 2025.
mm. The learned counsel for the petitioner, Ms. and such, and learned government advocate, Ms. Livika. Stop. Here, how many petitioners?
One petitioner, Your
One.
Lordship.
Para. In the present petition, the petitioner submits that he was appointed as a work charge labor with effect from 21/6/1992 with employment code number MON/0056 and posted under the subdivisional officer Pomching, POMCHING, under the establishment of executive engineer PWD RNB Mon division Mon Nagaland. Stop. Para. The petitioner states that he has been serving the department as work charge labor continuously for more than 31 years, and he was paid an amount of rupees 5,250 per month. However, the salary of the petitioner has not been released with effect from January 2021 till date. Stop. It is further submitted by the learned counsel for the petitioner that his name and particulars have been verified and the same have been found to be tallying with the PIMS. Stop. To this effect, a letter has been written to the Chief Engineer PWD RNB Nagaland Kohima by the Executive Engineer PWD RNB Mon Division by letter dated 26th May 2025, stating that the petitioner who falls under, no, you just replicate this letter, okay? That and such. And therefore, the petitioner states that a direction may be given to the state respondents to release his salary with effect from January 2021 till date. Stop. Learned Counsel, Learned Government Advocate, Ms. Levika, has fairly submitted that as the petitioner's particulars and documents have been found to be tallying with the PIMS, comma,
It's for the letter dated.
as per the letter dated 26 May 2025, this petition can be disposed of at this stage. Stop. Para. The court has considered the pleadings of the petitioner and has also perused the letter dated 26 May 2025 produced by the petitioner and has is of the view that there should be no impediments for the state respondents to release the salary of the petitioner. Stop. Accordingly, this petition is disposed of with the direction to the here also PNR is party, na?
Yes, Your Lordship.
To the respondent number 2 to give what was that clearance? No.
Now, as per this
To-
letter, his name has to be entered under the.
No,
category-
first,
under
yes,
A
yes, no.
category.
Wait, okay, first the C has to submit actually. So the respondent, direction to the respondent number 5. No, respondent number 5 and 6 to forward the particulars of the petitioner to the respondent number 2, to the respondent number 2. And thereafter,
To merge the state in under
Under-
category A. Because now
to
it's
the
been-
respondent number 2 to merge the name of the petitioner under category A. A, you put in inverted commas, okay, under category A. And the petition and the respondent number 2 shall thereafter take steps for necessary clearance of the petitioner under PIMS. Stop. And thereafter, the respondent number 5 and 6 shall release the salary of the pending salary of the petitioner with effect from January 2021. The entire exercise shall be completed within a period of 2 months from the date of receipt of this order.
Much better.
Actually, the petition is disposed.
For hearing, item number 22.
Yes. Is it a long matter, short matter?
Several cases.
Hmm.
Disciplinary, language,
On what?
I'm the landowner and
A landowner,
my ancestors.
donated land.
Land for some, office.
Hmm.
My contention is that till date,
Hmm.
no one has been appointed.
Hmm.
And I have submitted an application against an vacancy, whereas my application was not considered.
Hmm.
And respondent number 6 was appointed. That is just the short facts of the case.
And respondent number 6 is not the landowner.
Not the landowner, and also second contention is that the appointment was made in violation of the constitutional scheme for public employment.
But first you have to prove your entitlement. No?
Yes, Lord.
Hmm.
Yes, Lord. There's also an agreement executed in the year 1980s,
Hmm.
where the land was also donated in the year 1960.
Hmm.
Additional plot of land was donated in the year 1960s.
Hmm.
There's a document with that intention.
Hmm.
Whereas for 1960, there's no visionary agreement, there's only oral agreement,
Hmm.
which is also provided under the notification.
Yes, yes, of course.
And in the year 1980s, another agreement was executed, which has also clearly stated that in the year 1960, a plot of land was donated by the landowners.
Hmm.
The only peculiarity of this case is that there are 2 landowners.
two landowners.
Oh.
The co-lane owner, they have enjoyed benefit on 3 occasions,
Mm.
whereas in my case, I'm yet to get their benefit, that is my.
For the same
intention.
plot. For the
Yes,
same
yes.
plot, two
The same
landowners.
vicinity for establishment of the office. Where's office? This falls in the Kohima town, falls in the Unauthorized district. The state, they have also filed their affidavit. They have admitted the fact that yes, 3 appointments were made.
Mm.
3 appointments. And I'm not disputing to that because those 3 appointments were made that, from the whole late owner's family, then from my family. And there's also a judicial pronouncement of this honorable court where it says that when there is a co-landowner or joint landowner, even the other co-landowner should also be given that benefit. That there's also a pronouncement of this honorable court.
But in view of 3C, clause 3C of the
Yes.
policy,
Yes.
how
Cannot
can
be a
there, how can
perpetuity.
there be, how
Cannot be a
can there be
perpetuity.
2, 3?
Yes, yes, I agree, I agree.
Because it says only one.
Yes, and that has also been discussed in the pronouncement which I'm I'll be relying upon. It has also clearly discussed about 3C.
Mm.
The co-landowners, they have already enjoyed the benefit. In fact, in that pronouncement which was passed by.
Can we hear tomorrow?
Yes, yes.
Today I'm
Yes.
tired now.
The Honorable Court had a long day.
Yeah. Pass over for the day.
First item.
Okay,
What first
fine.
item?
As first
My
item.
lord, my lords, if I may,
Yes. Yes, the
I
other
appeal
all pass over. Yes, which one is your case? Item
23 and 24, my lords.
23 and 24. Tomorrow?
My lord, my humble request is that we haven't received any counter affidavit. The matter may be kept for final hearing ex parte if that's permissible.
No, but CGSC, where's CGSC? CGSC is here only. They have not filed counter affidavit.
No, my lords. We haven't received any counter affidavit till date.
Anyone here? Young or what is? No one.
Maybe a final opportunity and then
Okay, 23 and 24. List after 3 weeks for hearing. So in the meantime, the respondents, only union is a party, na?
no, my lords. There are 3 parties.
Union of India and
Union of India, Deputy Commissioner of State Tax, Enforcement Officer, HQ Nagaland, and Assistant Commissioner of State Tax, Ward E, Dimapur Zoo. And Mr. Anupam Roy.
a private respondent is also there.
Yes, ma'am.
Okay. In the meantime, the respondents are allowed to file their affidavit in opposition if so advised.
In the interim order,
and the interim order passed earlier shall continue till the next date.
Obliged.
Any more? That's all, no?
Master.
Okay, first item, hearing list.